for a pretrial, 10 o'clock.
State of Ohio versus Tracy J. McDonald, case number TRC 22-2574, ABC, D and E.
Tracy McDonald is here, he missed a hearing Monday. I'm going to order that he get a urine screen and then come back before the court after that's been done. So go do a urine screen.
Your Honor, if I may, he also turned in 5 days of community service that I need to verify.
Okay.
State of Ohio versus Melanie Neese, case number CRB 13-1147, CRB 10-1104, CRB 08-1315.
All right. You are Melanie Neese.
Yes.
And this was a case that had been set for review hearing August 7th at 9 a.m. of this year. And Celeste, you did show up at that time. Do you admit or deny that?
I admit that I did not show up.
Do you have an explanation?
I didn't have a ride. I've been taking care of my mother
Where does she live?
in South Point.
Okay. Well, it's not that far away.
I know.
You got to get here to court. You're lucky. You had a warrant outstanding, so you're lucky you didn't get picked up in the jail. So I'll cancel the warrant since you did come in today. You've got some community service to do and fines to pay.
Okay.
Can you pay anything on your fines today?
I did today.
Okay. You're right, you did. Okay, you still have community service to do. You can get 2 days credit for tomorrow if you come out. Set your next hearing for November 6th at 9 o'clock. Withdraw the warrant. November 6th, 9 o'clock. Get this stuff finished and quit coming to these hearings.
Thank you.
You're welcome.
State of Ohio versus Destiny Gerald, case number CRB 23-595.
And are you Destiny Gerald?
I am.
Ms. Gerald, it's alleged that Fayette Township, October the 3rd of 2023, you purposely tried to deprive Walmart of property without their consent. It's a theft charge, maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead to this?
Not guilty.
You want a lawyer appointed?
Yes, please.
Do you have a job?
Yes.
What do you do?
I'm a cook at Tutors.
Are you paid by the hour?
Yes.
How much per hour?
$10.
Okay, you're eligible for court-appointed counsel, and I'll appoint Mr. Steyer to represent you. I'm hearing a not guilty plea for you. She has a bond up, so that bond is continued.
I see your paperwork.
Okay.
Thank you.
Okay, I'd like to set this October 23rd or after, anytime October 23rd or after.
Take a look at my calendar, Your Honor. I'm actually here on the 23rd.
Okay, October 23rd will be the next hearing. Pre-trial at 10 o'clock. Not guilty pleas and
No, what time? 10 o'clock.
10 o'clock.
State of Ohio versus Roger W. Smith, case number
Yeah, just
CRB
wait for me. I'll be there in a minute.
23-314.
Oh, wait, here, hang on to this, I'm sorry. But yes,
Roger W.
I
Smith.
misunderstood you.
Mr. Community's case.
we need Mr. Means in the courtroom. We're on pre-trial. Roger Smith.
Your Honor, this was a 90-day continuance, was going to be dismissed with no further problem. The cost has been paid. I don't believe there's been any further problems that have been brought to my attention, but
Get the prosecutor to confirm that, and then we'll dismiss it. He did pay the cost.
I believe Your Honor had indicated that if he paid the cost and there were no problems, he didn't have to appear.
Yeah, we're starting the pre-trials now, so we need the lawyers to come in.
Pre-trials, Roger Smith, it was a dismissal upon paying the cost with no problems.
Have there been any, we don't have any indication there have been problems, Your Honor.
Case will be dismissed.
Thank you, Your Honor.
Are we doing pre-trials?
We are starting.
State of Ohio versus Stephen Dodgen, case number TRC 23457, A, B, and C. Stephen Dodgen.
Your Honor.
Good morning. Set for pre-trial today.
What's up, Phil?
How you doing?
I'm good.
Is he doing this?
Yeah, he did it. They should have sent it in. If not, he's got his card. Please.
Do you have approach, Your Honor?
Yes.
That's part of it. They said they should send this to.
State is in agreement to dismiss this case. Was that for some evidentiary issues, Mr. Field?
Pardon, Your Honor.
The basis for the dismissal was evidentiary issues, or?
Yes, Your Honor, the basis for the stop was, we felt, in the circumstances, probably not sufficient to go forward.
All right. Case will be dismissed.
Thanks, Your Honor.
You're welcome.
State of Ohio versus Melissa Wheeler, case number TRC 231295, A and B. This is Mr. Scott's case.
Mr. Scott, who is now in the courtroom, set for pre-trial. Melissa Wheeler.
Judge, this is a DUI case. Defendants gave discovery. I still have to review the dash cam footage. Discussed with Mr. Hill this morning. Ms. Wheeler is now eligible for LDPs. So we'd make an oral motion for her to have LDP. She does work, and she's having difficulty getting to work. So we'd ask for those to be granted at an entry in a few moments.
State's position.
We're not opposed to her having limited driving privileges.
All right, you'll prepare an entry.
Prepare an entry, just ask this to be set in approximately 2 weeks, Judge.
October 23rd. October 23rd for pre-trial, 10 o'clock.
Be outside.
Okay.
State of Ohio versus Joseph Brazos, case number TRC 23999, A, B, and C.
Mr. Each's case, and it's set for a pretrial motion is what I have.
Correct, Your Honor.
Is there anything the court can do to facilitate this?
Scheduling, Your Honor.
Okay, so we're not going to be able to resolve it without an evidentiary hearing?
I don't know, Your Honor. Mr. Hield and I will continue to discuss the case up into the suppression hearing, I expect. I'm fine, October 27, November 3, 17, or 24. Makes no difference to me.
Okay, what were the other dates other than October 27th?
November 3, 17, or 24.
Your Honor,
Mr. Hill.
well, in anticipation that this would probably get set for evidence, I've requested of the trooper to tell me any dates going forward that he might not be available. And I think he worked last night, and he hasn't answered me yet. So what we would like to be able to do is move the date if we need to.
That's fine, Your Honor. I understand.
All right, November 17 at this point. Motion hearing at noon for evidence. November 17th will be the next hearing.
Thank you. Very good.
State of Ohio versus Amber Kelly, case number TRC 231026, A, B, C, and D.
Your Honor, this case also comes on for a pretrial on my motions. Mr. Hield and I have discussed this case. I anticipate a resolution. At this point, the defendant's going to ask the court to set this for another pretrial, not a motion hearing at this time. There are some things we need to have in place before we resolve the case. So I'd ask for the November 17 date would be fine, Your Honor.
Okay, but it'll be just a regular pretrial.
Yes, sir. I also filed a motion for limited driving privileges.
There's no objection. Fair.
Yes, sir.
No, there's no objection.
All right, November 17th, pretrial 10 a.m.
Thank you.
State of Ohio versus Thomas G., case number CRB 23480.
This is Mr. Lambert's case,
Yes, Your Honor.
and it's set for a pretrial.
I wonder if she's here. Is Emily G. here?
Yes, right.
You want to come up here, please? Your Honor, I have Miss Emily G. here. She's the alleged victim in this matter, and she's written a letter for us today explaining that she does not want a protection order at this time, which we are willing to agree with her on that. And also, I think that they're in the process of dissolving their marriage, and we want to get through that process and make sure there aren't any further problems. She wants us to dismiss the charges, but what we want to do is hold on to the case for approximately 90 days. And if there aren't any further problems, and if the court costs are paid at the end of that, we'd be willing to dismiss the charges.
Mr. language.
Your Honor, the separation agreement has already been signed, so there are no issues. It's just a matter of the divorce being set for a final hearing. So I think it'll be within the next, let me see when it was filed. I got a copy of it. Filed August 31st, September, October, we have 6 weeks, so it ought to be finalized by the,
Are there children involved?
no children involved. And we have agreed to a restraining order in the divorce, Your Honor, so.
Okay.
And it's my understanding there's been no contact between the parties since this incident.
Well, if we go into December, that would be 90 days from the time of the arraignment. Is that sufficient, Mr. Field?
Yeah, we're not opposed to that, Your Honor.
Mid-December, what's your schedule, Mr. Ryan?
The 8th would be fine, Your Honor.
All right, December the 8th. Case will be dismissed then if there's no further problems and costs are paid. If that happens, then Mr. D does not need to appear.
Okay. And if there is a problem, Mr. Hill will make a note to let me know.
Or if the costs aren't paid, he has to appear then.
Yes.
Okay, December 8th is the next.
All right, so no problems, you don't have to show up. If there's a problem, then we'll let you know. Okay. All right, you're ready to go.
Randy,
Oh, wait a minute.
that's just the time.
State of Ohio versus Ellen R. Phillips. Case number CRC 23-546 and CRC 23-1249.
Oh, I got it.
Mr. Holt's case is set for a pretrial.
Your Honor, I believe we've reached a resolution in this matter. In exchange for anticipated recommendation from the state, Ms. Phillips entered a plea of guilty, and we also filed a motion for limited driving privileges. She is employed, and she's her child's sole source of child care and transportation.
So there is a change of plea then?
Yes, Your Honor.
That's guilty?
Yes.
Is that correct, Ms. Phillips?
Yes.
You have a right to make a statement to the court. You're not required to. Do you have any statement you wish to make?
No, thank you.
State have any recommendations on sentencing?
Your Honor, this is a first offense. The breath alcohol score was .137. We are not opposed to a suspended jail sentence. With the completion of the driver intervention program, we will take no position on, well, a 6-month driver's license suspension, but other sanctions we will take no position on.
Yes, Your Honor. My understanding, she would get, I believe it was $375 is the minimum fine, I believe was the agreement we had reached.
All right, I'll impose $375 as the fine. Order her to pay the court costs. 6-month license suspension, which will start as of the date of the offense. 20 days in jail, which I'll suspend on the condition that she does 5 days of community service and goes to the driver intervention program. The closest one now is in Portsmouth. There's not one here in Orange County any longer.
Get you information.
You can go to any program that's approved by the state of Ohio, any driver intervention program approved by the state. You just have to furnish proof that you've done it. You'll be on probation for 2 years, level 4 probation. You'll have a review hearing on April the 5th of next year. So what that means is you got all that time from now to April 5th to get this stuff done. If you get it finished, you don't have to come to the hearing. It's a hearing to make sure people do what they're ordered to do. If you don't do what you're ordered to do and you don't show up for the hearing, that's the only way you can go to jail, because then I have to issue a warrant for you for not doing it and not showing up. If you complete everything, you'll never have to go to jail. On the window tint, I'll impose a $20 fine. And I think that's everything.
Yes, Your Honor.
She'll need to see Mr. Major in the probation office. She's free to leave after that.
With the driving privileges motion, would that be included in the entry?
Yeah, we'll put that in interest. You can have limited driving privilege, and she'll get the actual permit from Mr. Major.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kendall Bryant, case number CRB 23-519.
While he's coming up, Your Honor, I have the entry of G if you want to
Okay.
sign it.
Kendall Bryant is Mr. Lambert's case. Set for a pretrial today.
You're gonna get us. Well, just give me a copy of it. Okay. And do you have the discovery then that you needed, or? Oh, that's right. Right, okay. We can just continue with that.
If we have 90 days, we can continue
Yeah, I'm not ready to commit to that.
Your Honor, I had filed a notice of appearance and moved it from next week to today so we could, because I was going to be here today anyhow and I wasn't available next week. I guess sent discovery. The state obviously hasn't had time to respond. I think this is something we can probably eventually resolve, so we move this, reschedule it, give them a chance to get discovery and us to talk.
I'm scheduling things now, the 23rd or after of October. Do you have a preference?
I just said we won't be here anyhow. How about October the 30th on a Monday?
That's fine. Next hearing will be October 30th, pretrial at 10 a.m.
State of Ohio versus Lee Kip, case number CRB 23-211, CRB 21-914.
This is Mr. Stratton's case, set for pretrial and looking for a report from the news.
No, Your Honor. The only thing we've been coming back for is paying on restitution. We sort of addressed this last time. He's completed everything, and we're just paying on restitution. I think he paid $100 last time?
Yeah, got 60 to pay today.
And he's got 60 to pay today.
Well, I think council needs to approach and look at this report that
I've got it here, Your Honor.
Your Honor, this is a new. You should have a letter in there from New Beginnings, that he completed New Beginnings.
That's the same,
Huh?
that's the same place.
It's the same place?
Yeah, I
Can
mean,
you see this?
no, he, what man did it? Me to go to Ironton. For the mansion. completed that. I did this on my own.
Okay.
This wasn't mandated, this was me doing this on my own.
Your Honor, Mr. Kipp said that this wasn't court mandated that he do this, and that he did it on his own. But I do know that we've been paying on this restitution is what we've been coming back for.
My plan said paid off by the end of the year. I thought everything was going somewhere smooth.
You know, I have ordered him in the past to do urine screens, and his first one was pretty bad.
We talked about a new behavioral health, you'll get report and dismiss with costs. But that, this is from back in June.
Back first, he was at Riverside Recovery.
No, sir, I did a screening there, and they sent me up to a new, basically.
Your Honor, he will do whatever the court requires of him.
Well, can I have that report back?
Oh,
That's my
yeah.
copy. You did not get a copy? I did not. You can get it from Gallery if you want. What's the state's position?
Well, the report from Anu, obviously, and that goes back to June the 23rd, that he was no longer in that program. We've been to court.
Well, it sounds like he refused to take a urine screen. They asked him to do a urine screen, and he left the office. Didn't do it.
And
that's why I'm reading the report.
Right. And so we've been to, this is the third time we've been to court since that time. So I don't know whether he's been involved in some other counseling at some other agency since then.
This was dated September the 8th.
Well, it says that on June the 23rd, that's when he left and didn't continue services.
Okay.
So, our goal was to...
Well, I think the last time he was here, we didn't have a report, so that's why I wrote and get a new report. So we got a report apparently after he had already been here for the last hearing. But it appears to me that substances have been a concern in the court, because I've ordered him. He's been tested by the court several times. And he has a case that he's on probation on, too, 21-914, criminal damaging. No, actually, I don't think it's been resolved. I think it was just,
That's the restitution.
yeah, restitution issues.
Yes, sir.
He's been paying on that.
He has made some payments.
Yes. Every time he's come, Your Honor, he's
$160 so far.
yeah.
I can have this paid off by the end of the year.
Well, what's the state's position? Does the state believe Mr. Kipp needs to be in some sort of substance use counseling? I see at one point it was also, this is way back, in 2022, he was, when Spectrum was still around, where he was doing outpatient anger management counseling at Spectrum.
Did that. Completed all that.
Well, he's never completed anything.
I completed the Spectrum, yes, sir. The anger management was asked of me.
Do we have a letter on
I gave it to, that should be in my file.
Yeah, it looks like the Spectrum gave us a report back on August the 1st, 2022.
Yeah.
About the non-intensive outpatient and anger management program.
He's doesn't say he's finished, it just says he's compliant.
Right.
Oh, no, they've got one in there.
And there it says completed.
Well, I don't guess we're gonna get any records from Spectrum at this point.
Probably not.
Actually, there's
I think it's important that he finish the, I mean, even after that, he's been involved in
Well, anyway, so it's been new, and then the last record I have from them is September 8th, saying that he
get back in that program, can they?
did not complete a drug screen when he was asked to there. And they were just monitoring, because I think he's been taking Suboxone, and they wanted to monitor his compliance. And he left the office for you, that's what I'm reading. 6/23/23, Mr. Kipp was asked to complete a drug screen due to medication compliance and policy, but he refused and promptly left the office. He did not continue with services or complete the remainder of his care after that time.
Your Honor, he's willing to do whatever the court wants him to do.
Well, I think today we need to do another screen today and see where we are, what our baseline is.
Yes.
Go from there.
Your Honor, his screen will not be clean.
Okay, well, I'd like to know what it will screen for, because
Yes.
even a lot of times when people tell me it's not going to be clean, they don't tell me exactly what it is. And I think everybody listening, you need to understand this. If you get anything off the street, you don't know what's in it.
Right.
You have no idea what you're getting.
Okay. So,
Even if they tell you, oh, this is meth, they have fentanyl in it. And that's what's taking people out.
you'll go take a screen, Your Honor.
Let's do a screen and have them go back.
Can speak to you outside, sir.
Screen. You'll be fine. We'll talk after you take a screen.
State of Ohio recalls L.R. Phillips, case number CRB 23546, TRC 231249.
Your Honor, there was a CRB case we didn't cover that was intended to be dismissed.
23546?
Yes, sir.
Oh, that's the possession.
Possession, yes.
Yes, Your Honor.
Okay, 23546 is dismissed.
Thank you, Your Honor.
State of Ohio versus Heather A. Blevins, case number CRB 23158, TRC 23261, A, B, and C.
Yeah, let's hold on just a minute for the clerk to catch up. Great.
Yes.
Okay. All right,
They've been
Heather
trying to
Blevins
find
is
some stuff, and it's just
Mr.
being busy.
Oh, is it?
Yes.
Christine Scott's case. Okay, this is one you talked to me about this morning.
Yes, Your Honor. Ms. Blevins is in Lighthouse. Apparently, they've been trying to fax over a letter this morning, and it keeps ringing busy. I'm not sure exactly what's going on there. If you want to recall it, I will. Can I text that to you?
And it's my understanding
Well, they
you
said
referred to this, is it called the Lighthouse
Yes,
by the court in Greenup County?
it's in Russell.
No, I mean, who ordered it?
Oh, Greenup County, right.
Greenup County Court
Yes, Your Honor.
ordered you to go to this program, and I think I'd ordered you to go to the counseling center. And they don't accept the counseling center. So I'm okay with, because you are an Ashland or a Kentucky resident, correct?
Yes.
So if this is a court, if this is a facility that court recognizes, I'd like to see something, you have something where the court ordered you to go there? I'd like to see that.
I don't have it with me. I mean, it's,
Well, I understand
they
that,
do
but you can
their.
get it.
Yes, they do, that's where they do their DUI school. And I'm doing it independent with her, 8 to 10 weeks, and then I wanted to follow up, continue from that,
What's the charge that you have in Greenup County that's pending?
a DUI.
Okay. Mr. Hill, what's your position?
Well, we agree, Your Honor. We just want to have something in writing from them and be able to keep up with her progress there.
So that case is still pending, it's not resolved? The one in Green?
It's resolved. I'm just finishing up all my stuff.
So you entered a plea there?
Yes.
You know when that was?
I mean, it was like a year ago. And it costs money to go to Lighthouse, so I had to get the money together.
Your Honor, the prior was in '23.
And was it the Kentucky case or? No.
The Kentucky case, I fought it for a year.
And we could be looking at a third then. Do we have results from the urine screen back?
Yeah, she pled on, this is a disposition.
Okay, so she's already, we're waiting sentencing then.
There was alcohol and buprenorphine.
Well, before I do sentencing in this case, I'd like to see that Kentucky file. So let's get the records from the Kentucky court. I want to see what happened there before I do sentencing here. And when can Ms. Scott be back?
Well, Your Honor, she said if she could appear by video.
No, she cannot.
Okay.
She's not practicing in this court. She needs to be here.
Yes.
And this lady hired her, right? Yeah, she needs to be here.
Your Honor, if we could set it for noon on a Friday, that'd probably be the best for her.
And, let's see, prosecutor should be able, I would think he should be able to get some of those records from your counterpart in Kentucky.
So what we need is...
Well, Your Honor, I've got this here that shows it was in Greenup.
Yeah, but I want to know the facts. I mean, this is very close in time to this case. I want to see the facts of what happened.
Your Honor, we'll have, at the next hearing, we'll have a Greenup order for her to go to Lighthouse, and we'll also have the Lighthouse letter for you.
I'd like to see the police report.
Police report, okay?
How about November the 6th, or you said a Friday?
Friday, yes.
November 7th, I think I just said something.
Did you say the 7th, Your Honor?
No, I was going to say the 17th. Did I not just set a hearing at noon on the 17th? Yeah, we've already got some stuff set at noon that day. Let's go up to, this has been around for a while, let's go November 3rd.
November 3rd.
Noon for sentencing.
She's also got a pending child endangerment charge. There'll be a pretrial on it.
So,
Sentencing and pretrial on the child endangerment.
they're not doing that today. We have no information from White House, and he wants to see the police report from Greenup County. I'll make sure Christine knows all that. Okay? All right? So make sure we have that Lighthouse letter next time.
Okay.
Okay? Thank you, Your Honor.
You're welcome.
State of Ohio versus Douglas Price, case number CRB 23276.
Your Honor, may I approach?
Yes. All right, Douglas Price. Is Douglas Price in court today?
Yeah, well, cover first.
Yes. Thank you.
Actually, it's a good report, but he's not here.
Okay, any idea why he's not in court today? No?
Your Honor, I don't know if there's a failure to appear prior to this. Was there a failure to appear prior?
There was on September the 18th.
Your Honor, I believe what probably happened was that he showed up and then got put on the docket, and then Mr. Thompson did not realize that he had showed up on a failure to appear. He does have a good letter, which is strange that he has a good letter and not here. I'll leave it up to the court.
Yeah, he came in on the 25th, and I guess I gave him this date, come back October 6th. So, from what I'm reading, he's only appeared once then, or? Okay.
He's had his assessment. He's scheduled to come in this coming week for his first session.
All right. State's position on it?
Well, Your Honor, one thing that I wanted to make the court aware of is that we want him to go to treatment, but we're not suggesting at this point that there would be some sort of agreement to dismiss the case. Might influence our feeling about what we would request as a sentence if he was found guilty. But we would also ask for a bench warrant in 7 days if he's not made an appearance.
Okay, and you can notify him of that. He needs to get in here in the next 7 days?
Yes.
All right. Be a warrant issued for failure to appear in 7 days if he hasn't appeared in that time frame.
I will let Mr. Thompson.
State of Ohio versus Seth Harrison. Case number CRB 23322, CRB 23403. Your Honor, this is Mr. Thompson's case. Also, there is a motion from the prosecution.
Well, I think it's going to be complaint first.
Complaint part.
No, because he's still telling me that he has nowhere to go, so I'm going to have to
But we have to be sure that it stays that way, right?
Yeah.
If you get something else that happens that you feel is inappropriate for him, you need to know and put the protection order back on again.
Okay, like right now he's fine, like I said, he's everyone know when he gets out, so I don't bring him back to my house, I'm afraid it'll make it worse and longer.
I don't want him to hurt you.
It sounds like what he's at right now, he's completely fine, like, you know what I mean, like he's leveled out.
Is he the Lawrence County jail?
No, he's the one that happens.
Okay, it kind of looked like the jail.
Basically, he's got a 60-day program to do up there, so he should get out of there on the 28th, I believe. We're supposed to be back here in the court on the 23rd, this month.
Okay. So, Your Honor, speaking with this young lady, she's the alleged victim in these matters, and she's asked us to ask the court to dismiss the protection order, and she feels that he's made significant progress. And she also says that when he is released from the program that he's in now, that he won't have anywhere to go. And that's understandable that she wants to make sure that he has a place to go, maybe to keep him from getting back into trouble, but I've explained to her that that's also a troublesome thing because we don't know what's going to happen when he's...
Well, I think he may be going back to jail. He was released to go to
that's true.
The hospital in Athens from the jail, so I'm assuming once he finishes, they'll return him to the jail, then he would come back to the court, and I could change his bond or whatever at that point. But I think they'll return him to the jail. I don't think they're just gonna cut him loose once he's finished his treatment there.
And
But-
she says that he finishes the program on the 28th of October.
Okay. We had set it for a hearing October 23rd. We just moved it up today because she wanted, as I understood it, she wanted to drop the protection order that had been issued. Is that correct, ma'am?
Yes,
And you are Christina.
Katrina,
Katrina?
yes.
Okay, well, it's in the complaint wrong then. How do you spell your,
Katrina.
okay. Yeah, it has Christina in the complaint. So, sorry about that. And I guess at this point, if he was released from care, and based on what you know about his condition now, are you, and your spouse, right? Ex-spouse, okay. Do you want him to be able to come live with you, or what's your?
He has no family, he has nowhere else to go. I don't want it to be detrimental to the process that he's made now, so.
Well,
It
that's
should
very
be
nice of
okay.
you, but you don't have, you have no obligation to do
I
that, you
understand
understand
that,
that?
I know. I think it should be okay. Like, as long as he stays on the medication and as long as he's doing good, he seems to be fine. It's as soon as he goes off of it, that's where we have a problem at.
I understand
And
that.
it's usually a few years in between when we run into that
Okay,
problem.
so it's not gonna be an immediate light
No,
switch?
it should not be, no. It hasn't been in the past, we'll put it that way.
Okay, I understand. Mr. Hill, do you have anything else?
No, Your Honor.
All right, at your request, ma'am, I'll withdraw the protection order that had been issued, and I'll put, I think that was a good date. I'm gonna reinstate it back on the docket for the 23rd, so we can, and this is Mr. Thompson's case, that is a Monday, so he should be here. So we can kind of plan for Mr. Harrison's release from Athens. So we might have to reschedule it again soon after that, but he's gonna be getting out the 28th, which is a Saturday.
He sees a forensic psychologist sometime this coming week. So
Okay.
that's supposed to be all that has to be done up there.
Well, I'm glad to hear that he's doing better. We get very few people that we can get admitted to that hospital, but when they do get admitted, I think everyone that I've sent there has done well. It's a good facility, and I'm pretty confident in their abilities to help people. So I'm glad he was
Yeah,
helping.
they seem to be doing it right this time.
Okay, October 23rd, 10 o'clock, you'll let Mr. Thompson know.
Yes, I'll text him here in a few minutes, Your Honor.
Thank you.
State of Ohio recalls Kenny Ingalls, case number CRB 20-128, CRB 19-847.
Your Honor, Mr. Ingalls entered ODRC April of '22 with 390 days worth of credit, which puts him, he was in jail since around March of '21, which I believe is the time period where he missed a court hearing. I do have a judicial release entry October 3rd. So
Okay.
he did just get out of prison, so.
Well, that's commendable, he came right in. So
Yes,
I'll
he did.
cancel any warrants on these two cases, 20-128, 20-128, 19-847. Okay, cancel the warrants, and then these are set for sentencing or pretrial, so I don't think there was ever a judgment entry finalizing it. So we'll put it on a date when, now, are you going to take over for Mr. Thompson, or you want Mr. Thompson to pick this back up, or how's that going to work?
It's up to the court, whatever.
Well, you've talked to him, Mr. Thompson hasn't talked to him for 2 years probably, so I'll just keep you on the case.
Okay.
And I'm looking at the 23rd or after.
Whatever's convenient for the court, I'm good.
Okay, October 23rd. For pre-trials.
I know your cases, I don't know what that's about.
10 o'clock, October 23rd.
Well, you're good for today. We'll discuss it.
Okay, we're going to go to the jail for some teleconference hearings now.
State of Ohio versus Christopher. Bryan, State of Ohio versus Christopher Bryan, case number TRD 222065. Joshua Carter is on deck.
All right, sir, are you Christopher Bryan? Mr. Bryan, I'm Judge Capper, the Lawrence County Municipal Court in Chesapeake. This is an arraignment hearing for you. This is an old case. It alleges that on July 13 of 2022 at 6:44 p.m. in Fayette Township, you were driving a vehicle with a suspended license. This is an unclassified misdemeanor. Maximum penalty is 500 hours community service and a $1,000 fine. And it's alleged you didn't show up for you had arraignment set for July 26th at 4 p.m. in the court in Chesapeake, and that you didn't show up for your hearing. You understand the allegation?
Yes, no.
How do you plead to the charge?
I was incarcerated at that time. I had other charges opinion. I ended up going through treatment after that, and everything else. I ended up, thought that's where I was supposed to appear. I was under the impression that it got taken care of when I came to court.
Which court were you in then?
I was in felony court down here, actually. I was on ankle monitor and everything at that time last time.
Were you?
If I may, I represented Mr. Bryan in that matter. The charge was dismissed, but to my knowledge, he stayed at Bethesda even after that charge, but I can't confirm whether or not he completed or not.
When did you get picked up on this warrant?
Yesterday.
Are you still living at Township Road 1186 South Point?
No, I currently live on 10th Street,
Okay, how'd you get picked up on this warrant?
I was at the gas station. I fell asleep in the vehicle at the gas station. They just done a welfare check, pulled in one of the spots. They ran my name and it came back that I had a warrant.
Okay. Well, how do you plead to the charge that you were driving while your license was suspended?
Guilty.
Okay. What I'm going to do, this is a non-jailable offense. You got jail time because you missed court. I mean, if you would have come to court, you couldn't have got jail time. So he's pled guilty. I'll accept a guilty plea. I'll impose a $150 fine, court costs, $30 hours of community service. Review hearing will be April the 5th of 24 at 9 o'clock. 2 years of level 5 probation. So you got to get this, pay your fine. You can actually work off your fine and court costs if you can't pay it by doing extra community service. You got 5 days community service, fine and court costs, and you got more fine and court costs and community service because you didn't come to court. You got to get more for not showing up. So the only way you can make this jailable again is what? Not do it and not show up for court. Then you're going to get another warrant and you could go to jail. So just do what you're supposed to and stay out of jail. Any questions? If you have any questions, you can call the court. We have phones here that people will reluctantly answer and answer your questions. And if you have access to a computer, you can go on and check your file online. Put your name in the record search and it'll show you what you have, when you're supposed to come back, what you're supposed to do. So there's no excuse for not knowing what you need to know to stay out of jail. Okay, you'll get out of jail today, unless you got hold of her for something else. April 5th. Just take care of it before then, you don't have to worry about that day.
I'll get it taken care of.
Okay, good luck.
Thank you.
You're welcome.
State of Ohio versus Joshua Carter, case number CRA 23599. Corey Portal is on deck.
Sir, are you Joshua Carter? Mr. Carter, I'm Judge Capper at the Lawrence County Municipal Court that's located in Chesapeake, Ohio. Your case is proceeding here for the arraignment. You're on a monitor and your image and audio, what you're saying is all being recorded. So you don't have to say anything, but if you choose to make statements, if you make any incriminating statements about yourself, those can be used by the state against you. You have a right to have an attorney, to have one appointed for you if you can't afford one, and have bond set and make the state prove charges beyond a reasonable doubt. You understand those things? The charge against you is breaking and entering. It alleges that on October the 2nd of 2023 in Union Township, by force, stealth, or deception, you trespassed in a structure with the purpose to commit a theft offense in that structure. That's breaking and entering. It's a felony of the 5th degree. Carries a maximum penalty of a year in jail, $2,500 fine. You understand the charge? You have the money to hire a lawyer. You have a job. You have no income at all coming in.
I'm homeless and have been for about 2 years now.
Okay. Mr. Morford, I'll appoint you to represent Mr. Carter. What's the state's position on bond? And where would you go, where have you been living, Mr. Carter, for the last 2 years?
In and out of the city mission.
Okay.
State's going to request a $10,000 cash assurance.
Okay, I'm going to set bond at $10,000 cash or surety. I'm assuming then that's probably a bond you can't post. So we'll need to come back quickly on the, when did you come into the jail? I'm assuming it was Monday?
Yes, October 2nd.
So we need to set this next Tuesday, or I think you're already here?
Yes, Judge.
Okay, your next hearing is going to be a week from tomorrow, October the 10th, for what's called a preliminary hearing, 10 a.m. Do you have any questions, Mr. Carter?
No, sir, I just want to say that I'm very sorry for my misunderstanding, and I will not participate.
Okay, Mr. Morford will call down and talk to you here shortly, and then we'll have a hearing a week from tomorrow about whether your case should be sent on to the grand jury. That's called a bind-over hearing, so.
Is that a week from tomorrow, Judge?
Yeah, because next Monday is a holiday. I'm sorry, this is Friday. This coming Monday is a holiday.
Okay.
So it's going to be Tuesday is when the hearing's going to be.
And you understand, Mr. Carter, just be here at the court of Chesapeake?
Oh, he's not getting out.
Well, we'll see. You got to help for it.
You're welcome.
State of Ohio versus Corey A. Cordell, case number TRC 23906, A, B, and C. Brittany Eplin is on deck.
All right, Corey Cordell.
Got the amendments.
Was discharged from OVP and picked up.
Yes, Your Honor, I arrested him Monday on probation violation for being discharged from OVP.
What say you, Mr. Cordell?
What did you say?
What do you have to say about things?
I have
say I got discharged by, I was arguing, trying to get a chief with stick in there too.
Well, in fact, originally, I think I sent him to Bethesda. Did he get kicked out of Bethesda first, or?
I think he just refused to stay there, so then we took him at OVP.
Well, yeah, I ordered you to go to Bethesda, and then you wound up at OVP, and then you couldn't even stay there.
Well, I had warrants in West Virginia also. I did the court date, being here.
Your Honor, Mr. Cordell ran from us the day we received him.
Okay. All right, well, here's what's gonna happen now. I mean, I sentenced you to 6 months in jail and suspended on the condition that you go to treatment. You left two facilities, got kicked out of one, left the other, so you get 6 months in jail. Sentence you to serve your 6 months and give you credit for any time you serve.
State of Ohio versus,
Can I go to, I was asking if I could.
No, you're gonna be in jail for 6 months. Then you can go wherever somebody has a holder on you.
All right.
State of Ohio versus Brittany Eflin, case number CRB 23589A and B. Charles R. Hall is on deck.
All right, Brittany Applin is before the court. Mr. Morford's her attorney. She was assessed by Bethesda, and they have a bed available for her for inpatient. And I've got a letter from Taylor Jones Duran about her willingness to go to treatment. Brittany, are you more willing to go to treatment now today than you were Monday?
I would like to go to treatment today so that I get my life back on track.
Okay.
I
Well,
like the way my life is.
and I was kind of ready to send you Monday, but I felt like you were still under the influence of methamphetamine on Monday, and I was afraid you would run. Afraid if I put you in the facility, you wouldn't stay there very long. You just hop right out and go out in the community, and there's a lot of dangerous stuff out there. So,
Yes, sir, I understand.
all right, I'm going to order her released to Bethesda for inpatient treatment. You're a very young person. You got a lot of life that you can live. This is a great opportunity for you. You got a child, right, that needs you in their life, but they need you in their life drug-free, not doing meth.
Yes, sir.
So,
I completely agree.
so you're going to a good place that can help you. I hope we'll take advantage of it, and I assume, Mr. Murphy, you're on board with all that.
Absolutely, Judge.
Thank you so much.
So I'm going to enter an order releasing you to Bethesda. They'll come pick you up today, and then we'll come back where this is going to work. They'll periodically give me reports. Well, they'll give me good reports periodically. If it's a bad report, Taylor texts me right then. If somebody's acting out or causing a problem, she'll text me right then. And I've had the police go pick up people from their facility immediately. I don't think I detect a totally different attitude from you today than I had Monday, so I think your brain is already starting to clear up. Just a few days off of drugs, and it makes a big difference in the way your brain functions. But it will continue to improve. The longer you are clean, the more your brain heals, the better your attitude will be, the better you'll do. So we need time for you in recovery. So that's what I want to see happen.
I completely agree.
Okay, so I'm going to see you back on October 23rd.
October 23rd.
Yeah, and hopefully I'll get a good report then. If it's bad, they'll probably call me before then. and I may see you early. 10 o'clock, October 23rd. So someone from Bethesda will come pick you up at the jail today.
Yes.
Thank you so much.
Okay, good luck.
You understand, Brittany, that the judge is looking for good reports?
Yes, sir, I do.
You're clean, be clean and compliant, and
Yes, sir.
turn this around for you, yourself, and your child.
Yes, sir, that is my goal completely, I promise.
Good deal.
State of Ohio versus Charles R. Hall, case number CRB 23596. Franklin A. Petty is on deck.
Sir, are you Charles Hall Jr.?
Yes, sir.
Mr. Hall, I'm Judge Capper at the Lawrence County Municipal Court that's located in Chesapeake. You've got a charge filed here in this court. You're appearing in the court now on a television monitor, so your image is all being recorded and your audio too. So whatever you say is going down on the records, plus this whole proceeding is being recorded. So you don't have to say anything. You have a right to remain silent. If you choose to make statements, what you say can be used against you. If you admit something that is helps the state, they can use it against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove charges beyond a reasonable doubt. You understand those things?
Yes, sir.
You're charged with a theft offense. And it's alleged this happened at the Walmart in Fayette Township here in Lawrence County on October 3rd of 2023, that you tried to deprive Walmart of property without their consent. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand this charge?
Yes, I do.
How do you wish to plead to it?
I plead guilty, sir, because I wasn't my wife saying all this. And if I can ask for a little longer to work it off on community service, I live right across the street from the courthouse.
You live in Chesapeake now?
Yes, sir, I do.
Because I had an address for you in Ironton. You don't live there anymore, North 7th Street?
No, I live right there at Travis Hotel.
No.
I'm willing to do community service to work it off.
Well, I haven't sentenced you yet, so what I typically do on people who plead guilty to shoplifting from the Walmart in South Point is make them take a urine screen, because I'm going to guess about 80% test dirty.
I got some boxing in my system and marijuana.
Well, thank you for the heads up, but I still want to do a urine screen. So I'm going to ask the jail to do a urine screen, and then we'll see after I get the results what I need to do for sentencing. So go do a urine screen, and I'll see you back here in a few minutes. Yes, sir.
If it comes back to what's in my system, we may all do my community service.
Oh, you'll have to do community service regardless, but if you're dirty for something that's illicit, I'm going to make you go get some substance use treatment. That's what's going to happen.
I have to take a drug screen right now,
Yes, sir.
so I'll talk to you, all right?
You will.
State of Ohio versus Franklin A. Petty, case numbers PRC 231427, B and C, CRB 23597. Preston is on deck. Preston is on deck.
All right, you're Franklin Petty. All right, and I need Mr. Steyer. Is he in the courtroom? Mr. Steyer.
Your Honor, he may be...
Oh, that's right, he went.
Yeah.
He had a funeral to go to, but he's coming back.
Yes.
All right, Mr. Petty, you've got several charges I'm going to go over with you, and I've already talked to a lawyer that I'm going to appoint to represent you. You've got a driving, now it's called operating a vehicle intoxicated charge. The state's alleging that on October the 3rd at 1:11 a.m. in Fayette Township, you were driving a vehicle while you were under the influence of alcohol, that you tested over the per se level under Ohio law for alcohol and by breath, 0.104. Maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. Minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. You're charged with failure to control your vehicle and improper handling of a firearm. What is that, the B or C, the improper handling? What level offense? An M4. All right, that's a M4, maximum penalty 30 days in jail, $250 fine. And then there's also a using a weapon while intoxicated charge, which is a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. I'm going to go ahead and enter a not guilty plea for you, and I've already appointed a lawyer for you, Mr. Steyer, who has been in court today and will be back later in the docket. I'll have him call down and talk to you. What's the state's position on bond for Mr. Petty?
The state's not opposed to an OR bond, Your Honor.
Will I be getting out today or no?
Well, the state says yes. They're agreeable to you signing a bond. So what that means is you sign a piece of paper that says, I promise to come to court, and if I don't show up, I get a warrant for my arrest, and then I have to pay $2,000 for not coming to court. So just come to court, you won't have to.
Okay, and here's another question.
Well, I think you should wait. Well, go ahead and ask your question, but don't make any statements until you talk to your lawyer.
Okay, can I still drive to work, or do I gotta have someone drive for
You
me?
have to have someone drive you, because as soon as you take the test over the, what's called the per se level, there's an automatic license suspension that goes in effect. So you are under a license suspension right now. So that'll remain in effect during the time of this case unless it's specifically lifted by the court. But here's what I want you to do. You got a lawyer. He's going to call you in a few minutes, and then you can ask those questions to him, and it's not on the record. Anything you ask me here, if you blurt out something that's against your interest, it's on the record and can be used against you. The prosecutor's sitting right here listening. He's not going to be listening in to your, and can't listen into your conversation with your lawyer. That's all privileged. So I think it's better that you talk to your lawyer and ask him some of these questions. He can answer those questions off the record. And then I'm going to let you out on a signature bond. Do you know where the court is in Chesapeake?
Yes, I've got a ticket there once this year where I had to pay.
Okay, well, your lawyer's here.
I'm back, Your Honor.
He just came in the courtroom. Mr. Steyer is back. So this is the one I spoke to you about this morning.
Yes,
Frank
yes.
Petty, so I'm appointing you to represent him. And he's getting out on a $2,000 signature bond.
Okay.
And he knows where the court is. It's across from the flea market on County Road 1 in Chesapeake.
Yes,
Okay, and we're going to agree on a date when you have to come back. What's good for you, Mr. Steyer?
Is this something we're waiting on results? You want to just go ahead and get back Tuesday so we
He took a
can?
breath test and tested over.
Why don't we come back Tuesday so that I can meet him and make the connection at that point, pick a further date to actually do a more substantive pretrial?
Okay, so Mr. Petty, I'm setting your next hearing this coming Tuesday.
Okay, Tuesday at what time?
at 10 a.m. on October the 10th. That's this coming Tuesday.
Okay,
Do you have a way to get to court that day?
my dad can.
Okay.
Can y'all give me a piece of paper to write this down to remember it?
Do you have a phone number for yourself or your dad?
My phone number is 740-337-8869.
Okay, I got 740. What was the rest of the number?
37-8869.
Is that 237?
Yes,
8669?
8869.
8869.
What's your dad's name?
Chester.
You know his phone number?
Can y'all look in the computer for my dad?
Okay. No, that's okay.
Tell you.
They said they're going a second.
Oh, they have it?
That's the number I put in this.
Nobody remembers phone numbers anymore.
No. It's got to be one that you've known your whole life.
Dad has changed his number, I don't know how many times.
Okay. Well, tell you what. I've got a number here for you, and we'll meet on Tuesday.
Come to the court Tuesday. It's really important that you be here then, October the 10th at 10 o'clock. You'll get out of jail here shortly.
Can my truck be took out of impound through my dad and give
Out.
my keys to?
I don't know that I can do anything about that today, but that may be something we can deal with Tuesday. I'll look at it today when I get the file. I'll see
That's
what I can
something you
do.
talk. That's another good reason for you to come to court, so your lawyer can help get your truck out of impound. Any other questions, Mr. Petty?
Not yet at the moment.
Okay.
All right, thank you.
You're welcome.
State of Ohio versus Kristen M. Preston and Jennifer Moore is on deck.
Kristen Preston. Ma'am, are you Kristen M. Preston? Ms. Preston, I'm Judge Capper, Lawrence County Municipal Court. This is an arraignment on a warrant. The allegation is you missed a review hearing on December the 8th of 2017. And it looks like you got a conviction for operating a vehicle intoxicated that was filed June the 9th, 2017. We're ordered to come back for a review hearing December the 8th, 2017. You didn't show up, and the only thing that you did on your case was you paid $25, and that was it. You didn't do any community service, didn't go to the driver intervention program. So that's the allegation. Do you understand that? And you have a right to have an attorney appointed to represent you on this because it certainly is a jailable offense. How do you want to proceed? I'm having a hard time. Maybe move the microphone closer to your mouth. Okay, go ahead, because he was very low. Yeah, a little better.
Okay, I'll look like to speak with an attorney. I thought that I would have the chance to do that today. But, I really don't know. I know that I had court, I couldn't get a hold of my attorney to reschedule my court date. And
Well, your attorney that represented you back then is still practicing in this court, but he's not here today. Roger Smith, do you want me to appoint, I think I appointed him back then. Do you want me to reappoint him to represent you on this matter?
I mean, if there's someone else, then I tried to get a hold of him several times and I never did get any response back from him.
All right, Mr. Stratton, I'll appoint you.
Yes, sir.
In the meantime, I'm going to set bond for you at $2,500 cash or surety. So you'll have to post that bond if you want to get out of jail to guarantee your appearance in court. And I'll set the next hearing. You think you can post a bond?
How much would I have to have?
Typically, that's $250.
I can try, I can't get a hold of my mom because she doesn't have a date card, any kind of card, or, you know, you can call her. So I've been having a hard time trying to get a hold of anybody. But I mean, I just recently started a job, and I'm recent.
Just a second, ma'am. Your Honor, I'll call down there, see if I can get her in contact.
Okay, I'm going to let your lawyer call down, talk to you, and be best have these discussions off the record, and
Yes.
then we'll have you back. If well, why don't I go ahead and set a date, and then if you want to have her back,
okay,
we can. Let's just set it for next Tuesday, October 10th.
October 10th.
Yeah, will I still have the bond if I can get a hold of somebody?
Yeah, you got the bond set. It's $2,500.
And what, I mean,
We'll let Mr. Stratton will call down and talk to you about it, and he can get in touch with the bail bondsman if necessary. Okay, that's all for now.
okay, thank you.
State of Ohio versus Jennifer Moore, case number CRB 23598. Charles Hall will be on deck when he finishes his screen.
Moore. And ma'am, you're Jennifer Moore. Ms. Moore, I'm Judge Caffer. This is your arraignment hearing at Lawrence County Municipal Court in Chesapeake. It's all being recorded. Your video and audio is being recorded. You don't have to say anything. You have a right to remain silent. If you choose to make statements, what you say can be used against you. You have the right to have an attorney, to have one appointed to represent you. If you can't afford one and you meet the criteria for that, you have the right to bail and to make the state prove charges beyond a reasonable doubt. Do you understand these things? Your charge is theft. So as this happened at the Walmart in South Point, which is in Fayette Township in Lawrence County, that you tried to deprive them of property without their consent. It's a first-degree misdemeanor. Maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charges? How do you wish to plead to this charge?
I'd like to talk to an attorney.
Okay, I'll enter a not guilty plea for you. Do you have a job?
No.
Do you have no income?
No.
Okay. I'll appoint Mr. Steyer to represent you. Not guilty plea is entered. This is Jennifer Moore. It's a shoplifting case from Walmart. She's got a Kentucky address, Langley, Kentucky. What's the state position on bond?
Your Honor, I'm looking through the criminal history that we've received. She does have some offenses in the past. I believe she's got a felony conviction. And a probation violation for that in 2017. We'd asked for a $1,500 cash or surety bond.
I'll set bond at $1,500, cash or surety. Is that a bond you think you can post, ma'am?
It would be a matter of posting roughly 10% more or less with a bondsman. Do you think there's somebody on the outside that could do that?
I'm not sure.
Well, we better set it pretty quickly.
That's what I would think, Your Honor.
October 10th, are you here then? That's Tuesday coming up.
Yeah, we just set a hearing for that date.
October 10th for pretrial, 10 o'clock. If you post bond, you have to get to the court, which is in Chesapeake. It's east of where you are now, Fort Huntington, on County Road 1. You have to be here Tuesday morning at 10 a.m. Of course, if the bail bondsman will give you the address, and you'll make sure you're here. Do you have a phone number where you can be reached by your attorney?
606-226-960.
Okay, I didn't catch that. I got 606.
969.
969?
9608.
Right.
Or I can give you my mom's number.
What was the prefix on that? I got the 606 and I got the 9608, but I didn't get the middle.
226.
226?
Yeah.
What's your mother's name?
My husband's name's Lori Bennett.
What's the last
My
name?
number is
Lori what?
Bennett.
Bennett?
Yeah, B-E-N-N-E-T.
What's her
Our
name?
phone number is 304-751-5534.
Mr. Hill.
Your Honor, I believe she's been in jail since the 2nd, so this is her 4th day. If Mr. Steyer had time maybe to reach out to her and talk to her about it and propose something to resolve this today, we'd be happy to talk about that.
Okay.
I'll give her a call.
Your lawyer's gonna call down and talk to you, man.
So, Jailer, could keep her out for a moment, please.
Okay, that finishes up what we can do for now. We'll be coming back because we got a urine screen, maybe some other issues on bond.
Yes, sir, we're still trying to obtain a sample from him, and as soon as I get one, I'll message you, Mr. Cooper.
Thank you very much.
State of Ohio recalls Lee D. Kip. That's Mr. Stratton's case. Case number CRB 21-914, CRB 23-211.
Your Honor, if you would notice in the court file, I did go through it and find the completion letter for Spectrum. It should have been there on top. Next.
That was a year ago.
Yes, and that's the letter that he had spoken about where he completed Spectrum,
Yeah,
so,
but he's got a case since then.
yeah.
And you seen the screen?
I have seen the screen too, Your Honor, yes.
If I recall correctly, the first case we had of criminal damaging was where we asked him to do the anger management counseling, and then the second case, the violation of protection order cases, I think where we started talking about substance abuse.
I think that's correct.
Yeah, so, let's see what he says. So, Your Honor, he's willing to get back in the program and do whatever the court requires of him.
Well, at one time, he was in buprenorphine. He was doing medically assisted treatment. Apparently, that's not the case anymore.
I'd like to get back if it's
Where were you getting your buprenorphine prescribed?
a new beginning.
Okay. Well, you haven't been there since summer, since
Yes,
beginning
sir.
of summer.
Yes, sir.
There in Ashland,
No, they're in Chesapeake, sir.
in Chesapeake.
Yes, sir.
They've got a 606 number on there.
Yeah, they're kind of hard to get a hold of sometimes. Every now and then it's,
She's not local, so we're not asking for.
Do you have a medical, Ohio Medicaid card?
yes, sir.
Well, I'm not too keen on them. I would prefer that you go to RRS or Bethesda. They're local, and they're here at court more.
Yes, Your Honor. Which would you prefer?
He's Township Road 1093.
Yeah, I was doing the one in Chesapeake because I don't have a license at the moment, and I was walking back.
RRS is right here in Chesapeake.
Okay, I was not aware of that, I'm sorry.
All right, Mr. Gwynn is here. You can talk to him.
See you.
He's gonna get you set up for counseling at RRS.
I know.
Let's come back October 23rd.
Yes, sir.
Speak to Mr. Gwynn, he's out in the lobby.
Yes, sir.
Well, he's about to go out in the lobby.
State of Ohio recalls Keitha Lowry if Mr. Stratton is ready for that case.
We are, Your Honor. So this was so, oh, I'm sorry. This is what's set for review. She's completed everything, so. Your Honor.
So we were trying to get a report.
Yes, Your Honor. I went through my emails and I have a email that doesn't say completed, but says she's going to be completed. Let me approach.
Yeah.
This is the last email I received from the counseling center. I have emailed him back and had no response yet. And Ms. Lowry has sat in front of my office and called the counseling center numerous times and talked to several different people and can't get anybody to give her any help.
Okay.
And she has done everything else that the court has required of her, everything. She's completed that and paid all her fines and court costs, I believe, and everything's paid. Some community service to do.
I did it. Yeah, I did my community service.
Yeah, I did community service too, so.
Ms. Lowry tells me that she has a copy of it at her house in Portsmouth, but didn't think to bring it here today.
Okay, do you have a way of either scanning it and emailing it, or?
Yes, I have work at 4, but also I can like take a picture of it and send it to you guys, or I can go into work earlier.
That would be fine. Why don't you do that? I'm going to set another, has she already been sentenced or not?
Yeah, oh yeah, Your Honor, it's a review hearing actually, so.
Here's what I'm going to do. I'll set another review hearing in a month, and you get that report in here, you don't have to show up.
Okay.
Okay.
So as soon as she gets it to me, Your Honor, I'll take care of the case.
Okay, so November the 6th, I'll make a note, only thing left is completion letter. Get that in, you're done.
Yep, just send that to him and that'll take care of the entire case. All right.
All right. Thank you.
You're all right.
State of Ohio recalls Tracy J. McDonald, case number TRC 222574, ABCD.
Okay, it's an acceptable screen. All right, so you just have your fines to pay?
Yes, sir.
You got a payment on your fine today?
I don't know, I brought my boss with me, so we'll see what we can work out.
Well, you can get out here tomorrow and get $100 off. If you
Yes,
do
sir.
community service tomorrow. Your next hearing is going to be November 6th. Once you've paid your fines, you can go come to this.
All right.
November 6th, 9 o'clock.
Thank you.
You're welcome.
State of Ohio versus Shane C. Blanton, case number CRB 20-853, CRB 20-715, CRB 2602, CRB 2690.
All right, this is Shane Blank. He's in custody in Scioto County, is my understanding, and he has a trial coming up in Lawrence County in Common Pleas Court soon. So they didn't transport him today. I don't think there's any reason to transport him until his trial's completed. So I'm going to go ahead and continue this to, you remember the date of the trial?
23rd of October, Your Honor.
Okay. Well, we'll set it for the 27th. October 27th will be the next hearing.
Would Shane Blanton call, Your Honor?
Yeah, I'm going to continue to October 27th. I'm assuming his trial will be completed by then.
That's the expectation.
Okay, October 27th for pretrials on review.
Thank you.
You're welcome.
State of Ohio versus Trevor DeMint, case number CRA 23514, CRA 23380, CRB 21167, CRA 2630, CRA 2321, CRB 2322.
Sorry. All right, Trevor DeMint is here. He's done a screen. It's a good result.
Okay.
Mr. Steyer is his counsel on the latest case. That's this 23-514.
Versus what?
How's the state want to proceed on that?
We have a letter from OVP. He's asking if the court would be okay with him transferring his mental health treatment from PATH to OVP. He's had an easier time scheduling and getting into OVP than he's having with PATH. So I think it might be more conducive to going forward with the treatment.
Mr. Healy?
We wouldn't be opposed to that as long as OVP is willing to do that. And I'm looking at the rest of this information here. It's a report from OVP today. And it says he's been compliant since he started treatment there.
You don't think that?
No.
That makes sense.
I'm trying. So we're going to keep the, because the 23-514 is actually a felon, we're going to keep it here?
Yes, Your Honor.
Okay.
Provided that he continues to do well.
Right.
November 6th?
Let me make sure we're not on my calendar, but I don't think there should be a problem then. I think November's pretty calm. In fact, I'm already on the docket.
November 6th will be the next hearing on all these cases.
Thank you.
Thank you.
State of Ohio versus Pena J. Lanhart, case number CRB 23447, A and B, CRB 23963, A, B, and C, Pena Lanhart.
Your Honor, Ms. Dalrymple talked to me this morning before, I think she may be gone before she left, and indicated that Ms. Lanhart had contacted her and advised that her phone, obviously that her car had some kind of a, I don't know what the problem was, but there was a problem with her car. On that basis, I'm going to seek a continuance.
She's here.
Oh, wait, she's here.
She's here.
Oh, okay. Well, I guess I've not been updated.
Here, Lynn. This is the last one.
She did arrive late, but she did show up.
All right. Would it be appropriate for a screen to be ordered here?
Your Honor, I've already tried to screen her. She could not screen, but she did tell me that she would be positive for THC and Suboxone. I've spoken with Josh Kraft. Depending on what her screen looks like, I'm gonna have her come in and meet with me probably Wednesday of next week. And depending on what the screen looks like, we may discharge.
Well, Your Honor, she just was speaking to me outside and she wanted to come in for a detox, so.
Okay. Well, I think that's probably a good idea.
How long is that program?
It's a 30-day program. She was on the phone doing her assessment and she got called in.
How long will it be before we can get her back over here then?
Are you not with Field of Hope then?
Yeah.
Is it like, I heard detox, I thought it was something different than what you're talking about, so.
It's just OBP recovery.
Okay, but you said detox, I was thinking it was like
Their program
2
is
weeks
30
where they're
days.
just gone or something, okay. So I don't think that would indicate, that would have any impact on when we came back then, is what is my point then.
If she goes to OVP, is QRT still want to stay involved with her, or?
I'm willing to.
Okay.
When would you like to try that?
I see where she did a screen before. She said she would be positive for marijuana and buprenorphine, but she was screened the end of August, and she had those things, but she also had amphetamine, MDMA, and methamphetamine at that time. So I think going to OVP is probably a good idea at this point. So she goes in today, she's gonna come out in approximately 30 days.
This will be her second positive screen on deflection, so this is really the last chance.
So Your Honor, I would think about the 27th or the 30th would be appropriate. Either of those would allow us to get her close to completion of OVP and then kind of regroup and decide where we're going to go next.
Let's do the 30th.
Thank you.
And you'll,
Oh, that's not
Brianna, you'll get her transported.
So you're going to have to figure something out.
If you're going today.
Yeah, she has to go now.
Yeah.
Yeah.
Okay, October 30th at 10 o'clock.
Thank you, Your Honor.
Your Honor.
State of Ohio versus Gregory Wilson, case number CRB 23515.
Cyrus Kids, Gregory Wilson. Yes.
Mr. Wilson texted me earlier that he was here, so I'm not sure where he is at this point.
Gregory Wilson.
Wait outside to get him the soda.
Your Honor, I would ask to have this recalled.
He's right there.
Oh,
He's right here, he's coming.
this is a matter that discussion with the state was that if he would undertake anger management and there were no further problems, that the state would be agreeable to a 90-day continuance with a dismissal. We came back in here today to make sure to get him started on, well, I guess this might be the first
It's
pretrial.
gonna take longer than that to complete the program, it looks like.
The end of January is when he would be done. So it's about 90 days.
End of January, looks like. I'm pretty free throughout January, so if the court wants to pick a date in that time frame,
January 26th.
that'd be fine, Your Honor.
Next hearing will be January 26th for pretrial. Defendant waives time.
Yes. 10 o'clock. Thank you.
State of Ohio versus Jacqueline Dillon, case number TRD 192682 and TRC 172192, A, B, and C.
On Jacqueline Dillon, I got a contact from Mr. Smith. She just had some other hearings where she's before other courts, and there was somewhat of a conflict for today, but it appears like she's doing okay. So I agreed to continue this to November 1st, another pre-trial. So November 1st for Jacqueline Dillon.
State of Ohio versus Sean DeWeese, case number CRB 22637, A and B. Sean DeWeese, did not check in, Your Honor.
This was Mr. Morgan's case.
This was one, the court costs will be paid, Your Honor.
Nothing's been paid.
Your Honor, the other provision for this being a dismissal was that there be no further problems between the parties, and our latest communication is that there have not been, but costs still need to be paid.
How do you want to proceed then?
We would ask for a warrant in 7 days.
Okay. Warrant will be issued if no appearance in 7 days.
Thank you, Judge.
State of Ohio versus Zane Smith, case number CRB 23560, CRA 23559, CRB 2340.
Mr. Morford's case, preliminary hearing and pretrial.
Zane Smith, domestic violence and disruptive public services. He was going to go to half, and I think he may have gotten us something from path before. We just need to get that. He's still in the path.
Oh, you got the, yes, sir. Judge, I have a report for you from Pat.
It's a good report. How do you want to go forward, Mr. Morford?
Judge, I don't know if the state's at a point where they can talk about dismissing this, or?
Oh, this just started. This case is just less than a month old.
Keep on.
Yeah, we're encouraged by Mr. Smith's commitment so far to doing this, and we want him to continue.
Yes, sir.
Continue on then, Judge.
November 6th?
December?
November.
November.
November 6th. For pretrial on both cases.
Thank you, Your Honor.
You are.
State of Ohio versus Hunter Tooley, case number number CRB 23147. Under cooler.
Looks like there's some progress made, but still work going on.
Agreeable.
Come back in another month.
Please, Judge.
November 6th.
Thank you, Your Honor.
You're welcome.
Good work.
State of Ohio versus Gregory M. Unruh, case number CRB 23571.
Maria Hannah.
Your Honor, we've made efforts at contacting Ms. Hannah, the alleged victim in this, and not been successful. No way to leave her a voicemail because it's not set up. Did we do a subpoena for her?
Yes, we did, yeah.
And we issued a subpoena for her. And she's not here today, so we're going to need to nolly this with the option to refile it if she would come forth.
Be nollied due to non-cooperation of the complaint party.
Thank you, Judge.
State of Ohio versus Kerry Wheeler, case number CRA 22765 A and B, CRB 22776.
Mr. Morford's case. Good report and good screens. Can we finalize any of these cases now, or?
She's done really very well. It's been a rocky road for Ms. Wheeler. A lot of things have happened that have been emotionally jarring for her, I'm sure, and yet she has done well in treatment. We've had the case for almost a year, 10 months. alleged victim of these matters, you know, he passed away, which is very sad, I'm sure, for Ms. Wheeler. Probably we're at a point where she's going to need to take on this by herself without the court's supervision. So probably it's time to go ahead and dismiss these charges.
All right, so, and that's both
Both of them.
both sets, so 22,765, 22,776, all are going to be non-voting at this point, which means dismissed now.
Okay.
So
Thank
good
you,
luck
sir.
to you.
Thank you, sir.
You made some big improvements. I hope you can stick with it.
Yes, sir.
Thank you, Judge.
I will.
State of Ohio versus Portland Hampton, case number CRB 23587, A, B, and C.
All right, this is set for pretrial. Ms. Hampton has indicated she is hiring Mr. DeWater. I think he notified the court that he's not been officially retained. Are you representing her?
I was representing her up to this point. Well, no, I'm sorry. What's your name?
Courtney Hanson.
Oh, I've got a different Hampton today. I misunderstood.
Your Honor, Mr. DeLauder actually called me this morning and let me know that he would be representing her, but he had a hearing in, I believe, the juvenile court this morning that was already scheduled. You know, we agreed that to just move this to another date. He didn't, I don't know if he gave us another date, but we're okay with doing that.
Do you have a date when you can be here?
He didn't indicate, Your Honor. I should have asked him. Okay.
So I need that amended, we need amended on the complaint and on my TPO.
He says he can do it October 16th.
Your Honor, we need to make an amendment on 23 CRB 587C. The victim's name is Mariah, not Marianne, so it'd be an H instead of an N.
And that October 16th is a bad date, so I'm telling him that's a bad date, we need a different date. So you want to amend on the name?
Yes, Your Honor.
And tell me again what it is?
The last letter is an H, not an N, on 587C. It's Mariah.
In the complaint party. Okay, I'll amend that. So he says he can do it the 23rd. So we'll set it for October 23rd. Next hearing is October 23rd at 10 o'clock.
You need to amend the
Yeah, I'll send
TPO.
a letter, I'll send a note to the sheriff's office, so
Okay.
I'll copy that note.
Thank you. Yes.
I'll send a copy of the
Thank you for your October 23rd at 10 o'clock, your next hearing.
State of Ohio versus Ty A. Grantham, case number TRC 23-1258, A and B.
All right, Mr. Grantham is here. Have you hired an attorney, Mr. Grantham?
I tried to, but I couldn't afford one because I had to quit my job because I couldn't drive myself to work.
Okay, you wish to be considered for court-appointed counsel now?
Please, Your Honor.
And I'm sorry, did you say you're not working now?
Yeah, I couldn't get to work because I'm not allowed to drive.
Okay, so you have no income right now?
No.
What had you been doing before?
I've been going to school still, but during the daytime, Tuesdays and Wednesdays.
But I mean, when you were working, what were you doing?
Oh, I was working at NGK in Sissonville,
What is that?
spark plugs,
Okay.
car automotive.
Were you paid by the hour? Or
Yes, sir.
How much?
14.
Okay, you're eligible for court appointed counsel then. I'll appoint Mr. Morford. Okay, so is this Nitro address correct for you? Okay.
Yes, sir.
So you're about an hour away, I take it, or maybe a little less?
Yes, Your Honor.
Well, I'm looking now. Dates are filling up. How about the 30th of October, Mr. Morford?
Judge, I think I'm good then. Yes, Your Honor, I'm here.
Next hearing will be October 30, pre-trial, 10 o'clock.
Yes, Your Honor.
What's your last name? I can read it. Grantham. What is it? Grantham. Grantham.
Where do you live? Nitro. 401 Main Ave.
I'll call you. Thank you, sir.
Take care. Thank you.
State of Ohio versus Ryan McLean, case number CRA 23584.
All right, Ryan McLean is here, set for a pre-trial. And did you post a bond, or?
Yes, Your Honor.
Okay, so you were supposed to either be in Marietta or be here today, so have you tried to turn yourself in Marietta, or?
I've spoken to my probation officer up there, and I'm supposed to turn myself in at the beginning of the week. I spoke to an attorney. I am a caretaker, and I had a doctor's appointment with them that I had to attend this week, as well as my treatment to get a Sublocade shot, is why I didn't do it this week. And I was coming to ask if I could have it extended out just till next week, where I am turning myself in and have spoken.
What's the date you're supposed to turn yourself in there?
On Wednesday morning, because I have court for a traffic ticket here on Tuesday.
So that's the 11th. October the 11th, you're turning yourself in Washington County?
Yes, Your Honor.
I'll continue your case then for 1 week to October 13. If Washington County has withdrawn the warrant on that date, you don't have to appear. If they haven't, you haven't appeared there, you gotta show up here and explain why.
Okay.
So I'll continue it for 1 week to October 13th at 10 o'clock.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio versus Brandon M. Waguzbian, case number TRC 231292, A, B, C, and D.
How do you pronounce your last name, sir?
Brownson?
Brownson?
Yes, sir.
Have you hired an attorney, sir?
No, I ended up going to outpatient at Ben Reed's, and I got my own apartment, and I cut my hours at work, so I wasn't able to afford one.
You want a court-appointed lawyer then?
Yeah, please.
Tell me about your working. Are you working now?
Yes, sir.
How many hours a week?
Like 20.
Paid by the hour?
Yes, sir.
How much per hour?
11.
Okay, you're eligible for court-appointed counsel. Mr. Stratton, I'll appoint you.
Yes, sir.
To represent Mr. Rousing.
Hello, sir.
It's an ODI case with the drug test score. How about the 30th of October, the next one?
Yeah, I believe that's okay, Your Honor. Just make sure. That should be okay, Your Honor.
October 30 will be the pretrial at 10 o'clock.
get treatment.
Your Honor, was this an arraignment?
No, this was a pretrial today, I believe. He had said before he was going to hire counsel, but he was unable to.
All right.
Browsing.
Oh, okay, I didn't understand.
You're welcome.
State of Ohio versus Randy Thompson, case number TRC 23-1301, A and B.
And Mr. Thompson, have you hired a lawyer?
No, it can seem a little harder than what I thought.
Okay, are you going to be considered for court appointment?
Yes,
Are you working?
yeah, I work 7 days a week.
Doing what?
I clean Valley House.
Are you paid by the hour?
I get paid by the job.
I have to determine your gross annual income, so.
2,100 every 2 weeks.
2,100
Every 2 weeks, yeah.
Okay, well, unless you got a lot of kids, I'm not gonna be able to appoint you a lawyer because you make too much money.
Just me and my wife.
No, you're making over $50,000 a year, right?
I don't know.
Yeah. So I can't appoint a lawyer for you. You'll have to hire one. What you could do is wait till you get the urine, you took a urine screen. You don't have the results back yet, I'm sure.
I wasn't
It's
sure.
only September the 5th. It usually takes longer to get the results back. And you can see what those are, then you can decide if you want to hire a lawyer after you see what the,
I didn't know I took a urine test.
that's what it says on the citation. It says urine. What's yours say, Mr.?
It does, Your Honor.
So usually that's a couple months to get those back. So we're just a month out now.
Yeah.
So let's come back. So Mr. Hickson, yeah, I got Ken Hicks' name on here. He's not going to represent you?
No.
All right, November 3rd will be your next hearing.
Okay.
10 o'clock. Hopefully we'll have the results from your urine screen then.
Okay.
November 3rd, 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Braden Thurman, case number TRC 23-1082, A and B. Braden Thurman. Did not check in.
Braden Thurman was said he would hire a lawyer, but he didn't show up today. And he's posted an OR bond. Will be ordered forfeited and a bench warrant issued for failure to appear.
State of Ohio versus Robert Reynolds, case number TRC 2510, A, B, and C. This is an arraignment.
On that last one, there should be a license forfeiture too. Okay, Robert Reynolds is here.
Good evening.
It's almost evening, well, it's afternoon now.
Yeah, we'll go afternoon.
Okay, you missed the
Last Friday.
review. Yes, September 29th.
Yes, sir. I have $108 on me to pay on my fine today. I believe this will be the last time I'll appear in front of you. I should have the other $400 by next Friday.
Okay. How things going?
Doing very well. Doing a lot better than I was 4 years ago, I'll tell you that.
Well, good. I'll cancel the warrant, make your payment. I'll set your next hearing for November 6th. If you pay it off, you don't have to come back.
Thank you.
You're welcome.
Ready for prelim, Sheriff.
Starting preliminary hearings now.
State of Ohio versus James Butts, case number CRA 23279, CRB 219.
Your Honor, Mr. Butts is in Lawrence County Recovery, doing well.
Yes.
And he's also been reporting with QRT and doing very well with QRT. So, and she had to leave.
She gave me a report this morning, and she did say that. She gave me a good report. Got a report. Thank you. Excellent report. Good job, sir.
Your Honor, I know that you had, the last time, ordered him to report to QRT once a week. I believe that's what your order was.
I think it's once a month.
Is it once a
Yeah,
month?
once a
I'm
month.
sorry, once a month, then. Sorry, I had it in my notes as once a week.
Yeah,
That's
fine.
right, so, never mind, Your Honor.
Everything's good.
Yep.
All right, since they're monitoring, I don't think we need to come back as often.
No.
So, do you have a projected finish date for him?
Yeah, it's the 17th.
Yeah, his
December.
projected finish date is the 17th of,
December.
Okay.
I had November, but it could always change.
Let's make it in December 4th is his next hearing.
Okay.
So 2 months out.
All right. Thank you. Thanks, Your Honor.
Good luck and good work.
Yes, sir.
State of Ohio versus Christopher R. Haley, case number CRA 23424, CRB 2487, CRB 1964.
Christopher Hale is Mr. Stiers' client, set for preliminary hearing and pretrial.
Madam President,
Yes. Very good report.
Yeah, this looks positive, Your Honor. Yeah. No, this is still, we're good.
He's got a good start, but we're just starting, right?
yeah, we just lowered his level of care to several living.
Okay.
Your Honor, we would obviously be willing to continue to come back on whatever time frame the court deems appropriate. And we would waive time constraints to accomplish that, to keep the case moving along here.
Let's make it November 20. Good job, Mr. Hale.
Thank you, Your Honor.
You're welcome. Keep it up.
Good work. Thank you.
Have a good day.
You too.
State of Ohio versus Mary Hampton, case number CRB 23321, CRA 23320.
This is Mr. Stiers.
Yeah, that was my confusion earlier, Your Honor. This is one that, I'm not sure if Megan's still here at this point or not.
I think she's left.
Okay. I spoke to her this morning. She said that Ms. Hampton is compliant, continuing compliance. We have here a felony charge as well as a shoplifting charge. They kind of rose out of the same incident. We are prepared at this time to enter a plea of guilty on the shoplifting charge, which Mr. Heald is making a condition of keeping the case here.
Is that correct, ma'am? You're willing to enter a guilty plea as to shoplifting?
Yes.
All right, I'm going to accept that plea, and based on my conversation, although she thinks she is compliant, talking about Ms. Dalrymple, After discussion, we thought it would be a good idea to do a screen today.
Okay.
So I wanted to do a screen, and then we'll come back and we'll finish things up.
Okay, is there somebody that?
I'll do it.
Okay.
Thank you.
Thank you.
State of Ohio recalls Jennifer Moore of the Lawrence County Jail, case number CRB 202598, and Charles Hall is on deck. Jennifer Moore at the jail.
Okay, we'll let Mr. Steyer go ahead and talk with his.
I talked to her, Your Honor, based on discussions with the state. She's been in jail for 4 days at this time. So the state is offered that in exchange for a guilty plea, they would accept a sentence of time served. She lives fairly distant away. I looked at where that city, the city that her address is on the map, and it's about 60 miles away. So for that reason, and also since she'd already done 4 days of jail time, we were not going to recommend community service in this matter, but obviously that's at the court's discretion, that she's about an hour away.
But I feel like I would want her to screen.
Okay.
So if we can let the jail know, they don't really need to put her out yet until we did get a screen from her at the jail.
Okay, I don't think they were, I hadn't talked to anyone over there about screening her, so do they have her, is there someone listening to hear that we're asking for a screen?
I don't know. We can text them and let her know.
Okay.
For more needs a urine screen.
Okay.
Who else is there not responding? Who's calling Charles Hall? Yes. State of Ohio versus Cameron B. Harless, case number TRC 2348 A, B, and C. This is the sixth.
This is Mr. Morford's case set for sentencing. He's at, Mr. Carlos is at RRS.
Hey, Duncan.
It's a good report.
Thank you.
So how's the state want to proceed on this?
We'd like to see him finish this program. He previously entered a guilty plea to the OBI, and we wanted him to be successful in treatment. Right now, it's a second offense, so we want him to continue on his path to recovery.
Okay. And especially if there's going to be an ask for no jail time, because there's a mandatory jail sentence on a second offense, but we've kind of been letting that slide on some folks that do intensive treatment for a long period of time. So that's a pretty big ask, because actually, if you look at the law, I'm supposed to give you jail time.
Yes, sir.
So, but my thinking on this is jail doesn't usually cure people. I can't say that there's never a time where it doesn't cure people of their substance use problem, but rarely cures people of their substance use problem. And that's what I want to see happen. You're a young guy. I want you to not have these problems going forward. So if this will do it, then it's worth that effort versus sitting in jail for a few days, which isn't going to probably help your substance use problem.
Yes, sir.
So, you may seem like, well, I've been doing this for a long time. Well, if you really don't want to do it, you can just go sit in jail for a while, or if you jail was a place to be avoided.
Your Honor, if I may, I think Mr. Harless has kind of adapted this to his own benefit.
Good.
He's made a lot of progress lately.
I see where he says right here that you committed to remaining absent for the rest of your career, and think that will help you in your employment. Well, the new study is out. I might as well get into that. The new, most recent studies say there's no amount of alcohol that's good for you.
Right.
And there used to be some studies that, or some thinking that a moderate amount of alcohol was good because it boosts your HDL, your good cholesterol levels, and some thinking that it was good for your cardiac health and so forth. But now they're saying the more recent studies show any amount of alcohol is damaging to the liver, even small amounts. Any amount of alcohol is damaging to your DNA. There's no amounts that are good for you. So I think abstinence is, you're right there on the cutting edge of what the new thinking is. So, and I'm going to applaud you for doing the right thing. So
Thank you, Your Honor.
so let's keep on keeping on, and then if I'm really convinced we're never going to see you back, then I can feel better about not giving you any jail time, even though it's a second offense.
Yes, sir.
Let's go into December. You've done good enough that I believe you're going to keep this up. How about December 4th, Mr. Morford?
I'm good then, Judge.
All right, December 4th will be the next hearing for sentencing,
Thank you, Your Honor.
10 o'clock.
Thank you, Your Honor.
Good work.
Judge, did I understand you say DNA as well, the liver?
Yes, that's what the new, it's actually out of Canada.
State of Ohio versus Sarah Osborne, case number CRB 23164, A and B.
Mr. Morford's case for sentencing. And Ms. Osborne's working with Children's Services, I believe.
That's all going as planned, Judge. She's compliant with her reunification plan.
We spoke with Children's Services this morning, and they indicated that she's doing very well at completing her counseling through the Children's Services case, and I'm looking here to make sure. Pardon?
Mid-degree, I think.
Yeah. The caseworker on her case said Sarah's doing well. She's completed her parenting classes. She's provided random weekly drug screens with negative results. Aside from marijuana, which she does have a prescription for, Sarah's been doing visits with her children unsupervised, and they are going well. Sarah is still doing counseling for mental health and AOD through her treatment provider. So it sounds like she's doing very well. What we want to do is make sure that she gets through the program so that Children's Services gets out of her life, and then it will be, she's already pled to the charge, and our recommendation as far as sentencing is going to be determined in large part by how well she finishes her Children's Services case. So far, she's done great.
Any idea when they're going to be finished?
Not yet, Judge. Have they given you a date? No, Your Honor, we have not received a date.
Okay, let's make this December 4th. I just set one for you for December 4th. We'll set this one too, so 2 months out. That's all.
Thank you, Judge.
You're welcome.
State of Ohio versus Heather Rieger, case number CRB 2214.
Okay, this is for sentencing on 2214. We've got community service. We've been waiting, not patiently, been waiting to get this done.
Your Honor, if I may, she has done 4 or 5 days of community service in this last time.
Wonderful. You can get 2 days credit tomorrow to come out. And there's going to be so many people there, I'm going to say there's not going to be a whole lot that you'll have to probably do. Probably get food and balloons and who knows what else they'll have there. Okay. November 6th will be your next hearing. Get it done and you can quit coming to these hearings. November 6th.
Thank you.
You're welcome.
Have a good weekend.
Dude.
State of Ohio versus Casey J. Jackson, case number CRB 22510, CRB 22165, CRB 222595, A, B, and C.
All right, Casey Jackson was supposed to be here Monday. He's here today.
Now, pressure her.
Yeah. And this is Tyler Smith's case, so he's not here today. Okay, well, it's, again, not the greatest report, but at least the last test was more acceptable than some of the others. I'm going to, and your lawyer's not here, so I'm just going to reschedule you for another day when I think you will be here. Let's see. He will be here Tuesday, so I'm rescheduling you for Tuesday, October 10th. 10 o'clock.
All righty, thank you.
It's coming Tuesday.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Mary Hampton, case number CRB 23321, CRA 23320.
Okay, do you have a prescription for this?
I do,
One thing is showing up,
yeah.
and it's been consistent. You tested for that previously. Okay, let's, go about a month out.
That's already done.
Our Mondays or Fridays better for you, does that matter? I'm asking.
Oh, it doesn't matter.
We set something on the 6th of November, that's about close to a month as we can call it.
All right, November 6th will be the next hearing. Preliminary hearing and pre-trial.
Thank you.
You are.
Thank you.
State of Ohio versus Charles R. Hall on a recall at the Lawrence County Jail, case number CRB 23596. Jennifer Moore is on deck.
Okay. Well, you tested for Suboxone and THC, so it wasn't as bad as I imagined it might be.
What was mine, sir?
You tested positive for marijuana, THC, and buprenorphine.
Yes, I was honest with you. Can you say I was honest with you, sir?
Yeah, occasionally people are honest with me, but a lot of times people lie to me. That's why I did the testing. So I can't take everybody's, if I took everybody's word for it, this wouldn't work very well. Okay, so I'm gonna go ahead and sentence you. Anything else you want to tell me before I sentence you?
Yes, sir. Yes, sir. I am willing to do anything like a restaurant outside, to better myself, and community service.
Okay. Well, you're gonna get community service. I'll impose a $100 fine.
Okay, my dad is bedbound, with 30 years old, and he ain't going to do that.
Okay, well, I'm sorry about that, but that is no excuse for shoplifting. So $100 fine, court costs, 10 days in jail. I'll give you, how long you been in jail now? Since Wednesday? Tuesday.
I've been 2 days, 2 days.
I'll give you credit for 2, I'll suspend 8, give you credit for 2. Order you to do 30 hours of community service and stay out of Walmart stores.
Yes, sir, I live literally 2 blocks from the courthouse. Is there any way that I can come to the courthouse to do community service?
Well, you can come here, but whether you come into the courthouse to do community service is up to Mr. Cooper. He's in charge of community service. He may send you someplace else. He may have you do something here at the courthouse. He may send you someplace else to work, but come here any day at 7:30 a.m. except Sunday or a holiday.
I got you. I will not bear the ever take my 3 fingers, look at me, I'm good.
Okay. And you gotta stay out of Walmart. Even, you can't go in there even just to look around, because they might pick you up for trespassing if you go in after you've been convicted of a shoplifting. There's plenty of other stores, so just stay out of Walmart. And your review hearing is April the 5th, so you've got to get this stuff done before April 5th. If you have it done before then, you don't have to show up. If you haven't got it done, you got to show up, explain why you didn't get things finished by April the 5th. That's a long time from now. You have any questions, Mr. Hall? Okay, I can't hear you. Your audio is off. It's probably on your headset. There's a switch on your headset.
Hear me now?
I can, yes.
I want to apologize to the courts for having to see my mug, and I want to apologize to you for shoplifting like a dummy because I was stupid. And you'll get whatever you need done.
Okay, just learn from your mistake and don't make it anymore. All right, that's that thing. You're going to get out of jail today.
All right, thank you.
You're welcome.
State of Ohio recalls Jennifer Moore at the Lawrence County Jail, case number CRB 23598. Mr. Major is printing off the results of her urine screen.
Mr. Steyer's case. She's entered a plea. I had ordered her to do a urine screen before I did the sentence. Okay. That's a good test result. So you're in medically assisted treatment right now? Or are you getting the buprenorphine off the street?
Can you hear us, ma'am?
Okay, your audio is turned off. Now I can hear you.
Okay, we got you now.
Okay, so you tested only for buprenorphine, nothing else. So if you're not getting it prescribed to you, okay, you need to get it prescribed to you. I'm not going to order you to any further treatment. I'll impose a $100 fine, order you to pay the court costs, 10 days in jail, and she's been there.
4 days, Your Honor.
Okay.
I'll give you credit, so 6 days suspended, 4 days credit. I'll order you to do 5 days of community service, and you can do it in your home area. What county are you in, Langley, Kentucky?
Christmasburg.
Oh, okay. South, on 23 South?
Yeah.
Okay.
Johnson County.
Find a charity down there, I'm sure there's several. Go do some volunteer work and get us, them to send a letter on letterhead that you've done the hours to the court. Your review hearing is April the 5th. You gotta show up here April 5th. If you haven't validated that you've done, paid your fine, court costs, and submitted your community service, and you gotta show up that day, or otherwise you get a warrant. They're not showing up. You get it done before then, you don't have to show up. You'll get out of jail today. Any questions? Okay. That's all then.
Your Honor, we have, they took Miss Lanhart into custody. She's in the back here, and we need to have her I'm sorry?
Let's bring her out then.
Okay.
State of Ohio recalls Tanya J. Lanhart, case number CRB 23447A and B, TRD 23963A, B, and C.
Just to the copy that goes to the court?
Yes.
Okay.
We'll finish at the jail, Your Honor.
Okay. Ms. Lanhart, I believe, was not willing to go today to OVP.
There was some discussion to that effect. I think she has changed her mind, is agreeable to go in today. I've spoken to OVP, they are still willing to take her, so we're asking that she be released and allowed to go to OVP, and we continue to go today.
And you're not going to run out the back door? Because I'll have to issue a warrant for you then if you do that. Okay,
Also, Your Honor, Megan is suggesting that she do long-term after the completion of OVP, so I wanted to let that be known.
Yes, and I think she sent me a text, I'm talking about Megan from QRT, saying you're going to have to do you need to do more than the 30 days if you want to stay with QRT, or they'll dismiss you from the program. So. All right, but today we'll get started with the release to OVP.
Thank you, Your Honor.
And the next hearing is October 30th.
Yeah, we just keep the same day.
Yeah.
This is 30th, brother.
State of Ohio versus Jonathan Sifford, case number TRC 23132A and B. This is a motion here.
Your Honor, we may need a moment.
Okay.
I think the trooper just went to the restroom.
Yeah, that's a good idea. I'll take a recess and then we'll start in a few minutes. So court will be in recess.
Thank you, Your Honor.
Do y'all play this with Ted?
We play Cold Grove at Cold Grove today.
We are up there.
Eh?
We are right there.
Yeah. You want just on break? Oh, you're gonna do the stationary. Oh, shoot, are these all unknowns?
Yeah. One of them, I had that one I gave you, that I had the little memorandum.
Yes.
To save you a little time, I have not complained about the walk and turn on my so that is not a part of my motion, so.
Well, I thought you were gonna try to trick me on that and say, he still has to do it all, he still has to show this and that.
Nope, you did that correctly.
You hear that?
Did that correctly.
I'm gonna,
We understand substantial
highlight.
compliance. It wasn't strict compliance, but it was close enough that I don't have any issues with it.
Do we have one from Friday or something that somebody didn't get out of the machine?
I think Mark was in last.
Mark, yeah.
That was Mark's.
Oh, yeah.
I can take that back.
Yeah. That was stuck in the, still
Unless
in
it was
there.
entered, I guess, if it was entered.
I don't know, I wasn't in here for it.
I don't know if that was ever, if he entered that as evidence or not.
I don't care. I mean, it's okay if we say he did.
Well, if he did.
I mean, it's the same thing as I.
Yeah, if he did, it would go in the court file.
Yeah, I'll put it in the court file,
Okay.
it doesn't matter.
Yeah.
I just gotta figure out who that was.
Yeah.
I'll figure out who that was and give it the, it's okay. We'll set up here next time we don't There you go, should be ready to go. I mean, the thumb drive is so much easier than the compact disc, because
And I'll stipulate to the videos
Wonderful.
that are provided.
You know, I couldn't find the backseat video.
Because it doesn't exist. Or it may exist, but it won't ever turn it over.
Yeah, there is a backseat video,
But that's
but it's not.
laid long after.
Yeah.
So, yeah, I've found that too.
But you could hear some of it on the
From
dash
cam, yeah.
which I may use some of that, but
I'm going to use some of it.
I'm going to use the part where you say,
Phil, how are you?
"Oh, all right, Alan, how you doing?"
Clearly that was failure to comply, for which he was already under arrest.
Phil, these guys tell me you're a little surly today, is that true?
Well, I don't have anything, I don't have any time to do anything except get ready for these hearings. And they think that that's a strategy.
No, I was telling them.
Well, I am surly.
No, I don't, I thought it was a long time ago.
Well, I know, but you knew it was there when you filed other ones, knowing that it was just going to create, that's not happening, shoot, it just, we stipulate that we know that we're using the.
Yeah, the printouts that you gave him, for the eye test, you can enter, I'll have no objection on those.
Yeah, I was telling them, I said, you're burning midnight oil in these cases.
Yeah, working every night on them. Plus, I've got my own practice where people are waiting for me to get their bankruptcy cases done. Those are time consuming.
It's not particularly reasonable to expect you to be able to do Monday, Friday, and Thursday, such as the way that the dockets are. I think Monday, Thursday would be okay because you've got a gap, but it's, I mean, I can do what you're doing. I couldn't do Monday and turn around and have Thursday, Friday, back to back with as many cases as there are.
The only, and I kind of tend to, if I let myself think that, then I would.
You don't have a choice at this point, like you have to. I get what you're saying.
Well, yeah, because the alternative may be worse.
No, I don't think so. I mean, I think it would be, well, unless you've got some.
One day here plus common police court, I'd pull my hair out.
I get that. I think that the sweet spot for you guys would be, and I don't know exactly how you would accomplish that with the present, well, presently you could with Jeff leaving, I don't know how you could accomplish it, would be you doing either Monday, Friday here and not doing our municipal, or you doing Monday, Thursday, and then have someone else here on Friday. I think that's probably the sweet spot.
I think that it's helpful for the court here if it's the same prosecutor for both days. That way you don't have to say, well, we have to do this one on a Monday or this one on a Friday.
It can be. Yeah, I agree with that.
I mean, I've thought about that it would help the dockets in municipal court if we had more grand jury.
Probably. I agree with that too.
Fewer of these cases that we know are going to go to the grand jury. Of course, there aren't that many of them.
Yeah.
But I would like to do that. I'd like to do grand jury and then learn how to do civil stuff from Mac. Because someday he's not going to want to do that anymore.
Mac's got living the life right now.
Yeah, but you know, those civil things, those opinions they come constantly.
Well, most of them that he does now, he's already done them, and he's just recycling his prior opinions.
Probably.
You know, like every year at a certain time, they get a bunch of opinion requests from trustees who are new, that don't know how to answers, and it's the same questions that he just answered for the prior trustees.
Yeah.
So he's got a pretty good, I've talked to him about it, he's got a pretty good repository. He's just like, yeah, I know every year I'm getting election questions about this, I'm getting this, I'm getting this. He's like, happens every year. And he can do that from his...
That sounds like a pretty sweet gig.
And he can do that from his condo in Lake Norman, if he so chooses.
Lake Norman? Is that North? No, that's North Carolina. Okay, it is like in North Carolina.
That was originally where I was going to practice, Iredell County.
One time, long time ago now. It was nice. So you're doing this and you're still doing your own practice?
Yeah, it's not. I don't do that much. I just do some bankruptcies and I do some guardianship stuff.
Say, how you got time to do all that?
No.
I was gonna say, you need an assistant.
An assistant wouldn't help me, actually. I mean, because this is all stuff that...
You gotta do the legwork on.
Yeah, I gotta do it. I mean, you know, I couldn't have somebody prepare one of these, because the most, I think, essential part of preparing for these, especially these suppression hearings, is coming up with snide remarks. And, no, I'm kidding.
We figured you'd just save those for Tyler.
A lot of them go that direction. I don't know, he's turned over a new leaf.
I was actually impressed when he got mine on the air. I was like, he had it in him this morning.
I started the day
A little
out.
far on Luke, though.
I think I gave him the finger, didn't I?
Oh, it'll be a little worse than that.
I used the F word.
He blacked out. He forgot what happened.
Well, you know, Luke, I can't stay mad at Luke.
No.
And he doesn't get mad at me.
The best part about Luke is when Luke has heard something, he's like, yeah, I heard that one. And then other times he's like, I did nothing to deserve that one, but I'll take it.
I think that's remarkable how collegial we do keep things, really. Because I can remember when I was a defense attorney 15 years ago, there'd be files being thrown in there. I mean...
You're going for kill shots?
Yeah, I mean, there was a lot of
gamesmanship,
angry words, and it doesn't happen quite as much anymore.
Yeah, I never stay mad. I log it and kind of go, okay, well, if I was going to kind of gloss over something, I may not this time, and then I just move on.
Yeah.
I'm the maddest when I'm alone in my kitchen doing these, and suddenly I'm overcome with rage at the attorney who's making me do all this.
I was impressed at our last hearing.
Look at all my notes.
You nailed me on that. That wasn't in my motion. I thought for sure it was. I looked at it. I went, can't believe it. I didn't think you read them. Other than past the first, like, so many pages.
Well, a lot of it's the same thing
Yeah.
every time. I mean, once you've read them once.
But I was like, huh, you got me. It's not there.
I did my memorandum of law on that last one and filed it this morning.
All marks.
Oh, that's right, it was Mark's.
Yeah.
So are we ready when the judge is ready?
Whatever.
Yeah.
He's meeting with some of the providers right there.
You got any other cases coming up? It's not me.
A couple of Brad White.
Oh, that's right, we talked about one. I forget which one that was, we just talked about it last week.
Yeah, that's old man at the gas station.
Oh, that's right, yeah, you told me.
That was not going to go well for him.
Yeah,
Not going to go well.
yeah.
He messed it up bad.
Does he do okay on the stand, or is he struggle, or?
Depends on the day. Some days he does better than others.
Yeah.
I haven't seen him on the stand in a while, so I don't know.
Yeah.
I mean, obviously, everybody with time improves. Well, usually. But the first time I had him on the stand, he admitted a whole bunch of stuff that he never should have ever admitted.
Yeah. I'm proud to say that I know I just started 70B and checked my clues I observed that night. I don't do scratch pieces of paper anymore. Mr. McCown set me straight on that one. He set me straight on that one.
Oh, so you're doing field notes now.
I'm doing, so the same concept, only I'll start to 70B. You know how we check the boxes on the
you
front?
just do it.
That's all I do, check the boxes.
That's a smart way to do it.
Yeah. And I don't destroy it when I'm done.
Well, we'll probably have to get those in discovery.
I knew, see, because you've told me stories before about where you look at somebody and you went, and I saw that look on you that day and I was like, I just messed up. And I didn't even know it.
You said it, I'm like, ooh, that wasn't good.
And then he lit up like a Christmas tree and I was like, this is not going to go well for me.
But those notes would not have given someone a clue as to what you were, unless you explained it.
I guess I understand that.
Somebody who's trained would figure that out on the notes, but I don't, quite honestly, it doesn't really matter to track anything unless there was a difference between the notes and what was on the 70B.
Right. I really thought he was going to lie into me because I'd sat on stand and watched that a couple days before, and it dawned on me then, like I could see, you know, just right there, real time, that what looked like a 10-sectomy on that one. It was just her taking a step to turn around, but it looked like every other step that she'd taken at that point, so it looked like a 10th step. And I remember when I realized that and I watched the video, I was like, oh boy, he's gonna have fun. And he never beat me up on it.
Yeah, because
Right.
came out with early.
Right. I thought he just did to make it
The
look
one I
stupid.
see more than anything that people get wrong is on the turn. Someone that their last steps on the line on the walk and turn.
Yeah.
And they don't do the turn like this. Their last steps on there, they'll go
Right.
this, and then they'll mark them for an improper turn. Well, that's technically not an improper turn.
You're right.
They
Never
didn't
thought
move
about
their-
that.
They
But-
didn't move their feet for balance within the turn. They just didn't do it the exact way that the trooper indicated that they should do it.
Yeah.
Technically, the indicator, the clue itself is moves feet with
Yeah.
you know, to do that. And so you can spin, you can pivot, however you want to do it, as long as you don't go.
Or you can't move, you got a pivot foot? Kind of like basketball?
Yeah, now
I didn't know that. I thought the series of small steps was one of those divided attention things where.
And the other foot, you're keeping it on the line.
Yeah, so as long as,
Touching the
but if
line.
you look at what the clue says.
You can't pick your foot up.
You can't pick it up. So if you do it like this, you're fine. But if you do it like, you go like this and you go like that, that's improper training.
That's traveling.
You move, yes, it's basically.
traveling.
It's pretty much what the rule
You
is.
did not dribble, sir.
That's a Eurostat.
The only other thing that I would be curious to hear, like a judge decide on, would be, it also says under that same section though, or turns in a way, any other than the way an officer instructed, basically. Is that, it has that caveat in there. It has that caveat of to turn differently than the way in which the officer instructed.
I don't know that it does. But I can tell you. Maybe. Let's see, that would be.
Which I'll be the first to admit, that terminology is pretty broad, but if I recall correctly, that is in there.
Let's talk for a second.
Yes.
It does say also record the clue. In there, you're right.
You see it in there?
Yeah, it does say also record the clue. It doesn't say it's an improper turn, it just says record the clue. Yeah. So a couple of things before we bother there. They didn't give me anything on the machine. They figured it out this morning. 12:04, they gave me an email that had a link to the inspection. We were rejected. I don't know what the judge will do. Because I'm not supposed to do this when I handed an email with the link in it that was just sent to them. It wasn't even emailed to me. So it's not on top of it. How did you get everything else together? So the other thing is, so he's kind of marginal. So wiring and mainly is going to be, it's going to be a little different suppression than normal it is. Some of it's going to be the same. So the argument is that the second that key, cuff key, you were removed. In the event that there's the second that will put you in the vehicle, so it's just going to be speed and how it's more. That won't be like this. We can keep it up. All of it's in contact. That's where we're focused.
Lawrence County Municipal Court is now back in session. Case for State of Ohio versus Jonathan Sipper, case number TRC 23-132.
Bill, the name are in the, your,
You can go down to see.
May we approach, Your Honor?
Yes. what are you thinking that none of the tips come in because it was under arrest?
So, once he's under arrest for that, you're not really left with one, because I think the only real reasonable suspicion you can argue was the admission that he was a leader. And so at that point, all we're left with is the, if the police from there would be monitoring the alcohol beverage, which would probably increase the size, it's not as strong.
What happened up to that point we have here? It's going really fast. The officer caught up with him and stopped him. And then he reached him again. And he stopped again. The officer caught him with the lights on. Then there was a situation where the officer was commanding him to stop and turn off the news. The guy had his hand on the clutch and he was trying to tell the officer, you know, take this off. Your sides on the car. And I think he wasn't really able to express himself clearly because of his impairment. I don't know if that's what other people see.
We already do that. We also have a camera in the back. There's a screen.
He didn't get his hand off of him until he was already handcuffed. So issues about his eyes and all that, he wasn't able to see any of that until they looked at him. Other than getting back. I'd like to, I haven't looked at any of the authority or anything on that. I mean, it seems to me under the circumstances, maybe it is reasonable to place him under arrest, but I haven't researched it, I haven't looked at anything. I mean, it just seems like a pretty terrible set of facts.
Sure. And then the agreement wasn't unreasonable to place him under arrest in terms of when he had to comply at that point. He's has to go on, and there were some issues with some of the audio that the camera is like probably something else that says, well, not only was you break, I'm going to grab you for federal law, but you stopped, it's just going to be
Why do they
sliding.
do that? We need to talk with them, because I see that happen all the time, not just this kind of case, but like, they write everybody for speeding, and then some guy doesn't have a driver's license, and he's speeding, they won't write him for the speed, so that makes no sense to me. I mean, they don't cut a break to somebody else. A guy with a driver's license is gonna get the speeding ticket. A guy without a driver's license is not gonna get a speeding ticket. It makes no sense. I really don't feel comfortable with this set of facts, just saying, okay, yeah, plead speed. I'd rather have the hearing, do the research, than make an informed decision. Okay, state and defendant ready to proceed?
Yes, Your Honor. Yes, Your Honor. We'll call Trooper B.
Trooper, will you raise your right hand, please? Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? I swear. Good afternoon. Good afternoon.
Trooper, can you state your name and where you're employed?
Trooper AJ Bean with the Ohio State Patrol at the IT post.
Were you on duty on February the 6th, 2023, and at that time, did you come into contact with Jonathan Sifford?
Yes, I did.
Where were you when this happened?
I was going out what we call Mont Hill, which is around milepost 18. I was traveling westbound on US Highway 52, and I checked the motorcycle coming toward me eastbound at a very high rate of speed, estimated the speed to be at 90 miles an hour. I checked it with my radar, the audio pitch and clarity were consistent. I checked the motorcycle speed at 100 miles an hour, turned out the nearest crossover, caught up with activator, initiated traffic stop.
And were you able to catch up with Mr. Sifford?
Yes, there's an intersection, US 52 and Walmart Way, which is the intersection, you know, where like Speedway is and things like that. That's helpful. The light was red. Mr. Sifford stopped at it in the left lane. While stopped at the light, at one point he looks over his left shoulder, sees me,
this light turned green, I immediately activated my overhead emergency lights and initiated traffic stop.
Did he stop right then?
No.
What happened?
So as the light turns green, I activate my overhead lights, like you said. He accelerates at a high rate speed. And I say high rate speed, I'm not saying 100 miles an hour again, but we're a 55 mile an hour zone. 75 is 20 over. That's a high rate of speed. Accelerates at a fast rate. And we continue through Sandusky, that intersection there, Sandusky Road, 152. Still doesn't stop. And then finally, as we come to a red light at Charlie Creek, County Road 144, he stops in the left turn lane while the light's red.
How far was that between Walmart Way and Charlie Creek?
Over a mile.
Were your overhead lights on?
And siren. I'd activated my siren.
And how far behind him were you during that stretch of the highway?
As closely as I could safely follow without fear at that rate of speed, rear ending.
Defendant was riding a motorcycle.
Yes.
At that point in time, did you feel that you were giving him clear notice that he was to stop?
Yes, lights and siren. He had already seen, he was looked back at me, at my vehicle prior to me initiating my overhead lights. Those are all three, for the length of distance, no indicator, high acceleration, 20 over the speed limit. Again, that's all indicative of somebody who knew I was there but intentionally did not stop.
Mr. Cremines, I believe you stipulated that the video is...
Yes, I'll stipulate that the videos that were provided to me were accurate videos and can come into evidence, the ones that were provided.
Thank you.
Can you...
Yeah, so at this point, I'm currently westbound on US 52. This is, when I activate my camera, it captured the 90 seconds prior to me activating it. So this is leading up to me observing the violation of speed.
About where are you on this?
At this point here, I'm right about milepost 19. This is going up on the way up, or getting ready to.
What is it to the left there? Right in that...
I'm sorry, I don't know what you did.
Oh, well, I was just trying to relate it to where it is on the highway. As far as
Oh,
yes.
Roads. Yes, yep. Now we're going up. You can see the eastbound traffic coming toward me. They're just getting down to the right.
And you'll be able to tell us when you see the vehicle that Mr. Siffer was driving?
Yes. Yes, sir.
Eastbound Sandusky, motorcycle RP Georgetown, boy 08, Georgetown boy 08.
I want to stop and ask you a question. At this time, did you see that he was looked back to see that you were there?
I'm sorry, it's hard to see from that screen, maybe if you look at that one, if you want to back it up, but, yes, he definitely looked back at me while I was stopped out of
I was going to say, Phil, if you want to use the button to the left, the back 10 seconds, that sometimes is easier than trying to maneuver it.
Yeah, okay. If you can see that now, I'm pulling it out.
Eastbound Sandusky, motorcycle RP Georgetown, boy 08, Georgetown boy 08.
Right there. At the about 3 minutes and 39 second mark. Does that sound about right? Is that the point at which you put your lights Now, from here, were you able to make face-to-face contact with Mr. Sitter?
Yes, I'm
If you recognize Mr. Sitter in the courtroom today, can you point him out, please?
Yes, sir.
Go ahead. Point to him.
It's right there.
President Shea, point of the defendant.
Did you direct him to turn off his motorcycle?
Yes.
How did he respond to that?
He had some problems getting his wording out first, but finally said I can't. Didn't elaborate until at a later point when he said that, he said his hand was on the clutch. I believe I don't do anything with motorcycles. I wouldn't know. That didn't mean anything to me. He later informed me though that if he released that clutch, he was getting ready to take me for a ride.
Did you get the motorcycle turned off?
Yes, I had the kill switch myself.
Did you order him off of the motorcycle at that time?
Yes, sir.
Now, what was your basis for ordering him to get off the motorcycle at that time?
Failure to comply. I activated my overhead lights and sirens. I had reason to believe that he already knew I was there. He looked back at me before I even activated him. I had my siren on. We still drove for over a mile before he opted to stop.
Did you place him in handcuffs and put him in the rear of your patrol car?
Yes, I did.
Was he still wearing his helmet at that time?
I had removed it prior to, so, as well as search his wrist.
Prior to
securing the rear of my patrol car. I handcuffed him first and then about removing his helmet.
And what was your reason for handcuffing him and putting him in your patrol car?
Arrest for failure to comply.
So, was he under arrest for that, for failure to comply at that time?
Yes, sir.
Turn it off. What? I
Fuck you off now. Turn it off. I said turn it off. Turn it off. Hey, turn it off. You just wait. I said turn it off. Oh, really? Really? Where's the speed? Turn it off right now. I'm telling you, turn it off. Do not turn it off. Do not turn it off now. You understand me? Okay, turn it off. You're left hand. I'm not letting you turn it off. I'm not letting you get the accelerator. You're gonna turn it off. You got 3 seconds trying to get your left hand. I want to fly. I can't turn it off. What? Use your left hand. If I left, if I leave my left hand, you're gonna try. If I leave my left hand, you're gonna try it now. You give me a chance. I'm gonna get a chance. What am I gonna do? Get off of it. I'm out of the freaking car. What do you want to do? My left hand is on your left, right? Where's the kill switch? Okay. That's freaking stupid. Get your case stand. I'm right. I'm fine. Okay. Get off the mic. Okay. What are you doing, dude? Get up. What are you doing? For real, you trying to stop? Get over here. Get over here. Let it throw my car. Hand right back. Freaking stupid.
Did you remove his helmet at that time?
Soon after he's handcuffed. I believe I did a weapons, I searched him for, including for officer safety, searched him for weapons. As an incident to the arrest, but too, I think that was, that removing the helmet followed that. My own concern was my safety first.
At that time, when you removed his helmet, did you start to observe clues that might indicate that he was impaired for purposes of driving under the OBI statute?
Yes, sir. There's various points of interaction with Mr. Sifford from this point all the way up through when I'll drive him out of the way of the highway in US 52. Whether he be here in the back of my car, I observed a water plus shop, or an alcoholic beverage, from this person. Right.
Is there anything about your initial interaction with him there at the bike that would have given you an indication that perhaps he was impaired?
There's several things going on here. So first and foremost, for whatever was going on with Mr. Sifford, granted, it didn't make sense. He got an outlet to a bridge right there, which he later tells me what his reason was later. But at this point, what I'm able to articulate is that you got a bridge within a mile or less from where he stopped. So why didn't he just stop a mile prior? That's odd behavior, odd thinking. That's thinking that it doesn't follow a sober mind, or what's going on there. Two, when he just keeps saying, I can't, without further explaining. He does later, obviously, you see that in the video, but know it's gonna be as soon as you look back at the stoplight. Don't have to, you don't know what I'm talking about, dude. We played that all day. I know you don't. I'm sure you do. What's your idea? Gotcha. Very nice. Stoplight. I put my lights on, you done it. Don't act stupid, dude. It's all on camera. Get in there. You jacked it up. I didn't. It's only gonna be a speed ticket. Now it's more. I did. He's been secured for 24, and he took off, his tan off, and realized he wasn't going to make it. I should not know.
Law enforcement, can you say all this, can you bring on?
Right.
Juan, Henry Davis, Juan.
Your audio went out.
Yes, sir.
Do you, and I would submit to you that it was from 6:58 on here until 13 minutes and 40 seconds, that there was no audio. Does that sound right?
Yes.
Do you know why that happened?
Yeah, you can hear me say before it mutes off or out of him, so it's one of the things that when we're talking about how we're going to move forward with everything we got, or so on and so forth, we're using our audio at that point.
And you had some other officers that joined you there at that time?
Yes, I believe, definitely Trooper Martin, and I believe Trooper White as well.
In his motion, the defendant alleges that you can hear on the audio from inside the cruiser that you said, "I'm only charging you with speeding because you stopped." Do you recall saying that?
Repeat that, I'm sorry.
"I'm only charging you with speeding because you stopped."
Okay, yes, at a later point, right? Okay, yeah, I remember. So what I'm saying there is, he obviously didn't comply, but if I tallied how many times people stop and they don't comply, Mr. Sifford might be one of my only ones. That's very rare. So I felt that because he stopped, that in and of itself, I was, I respect that, so I'm not going to charge him with it.
You didn't turn in a report for failure to comply, for a charge to be filed, right?
Correct.
And was that the reason why, because he stopped?
Correct.
The defendant also says in his motion that you told the defendant, just because I'm not charging you with anything other than speeding right now, doesn't mean I'm not towing your bike. Sorry. Do you recall saying that?
Yes.
And what did you mean by that?
So you got a whole pattern of reckless behavior. It started with 100 miles an hour. You have another high speed. Whether he stopped or not at the same time, he's made a reckless decision on that bike. Furthermore, it's no roadway at that point.
And the defendant also says that he admitted to you that he had one beer.
Yes.
Is that true?
Yes.
Did you administer standardized field sobriety tests?
Yes, I did.
Did you have to change the location to another place in order to do that?
Yes, you can see the very corner of the building on the right side of the screen there. That's the Clark's Marathon gas station. I drove us into that gas station lot for standardized sobriety testing.
Have you been trained in the correct administering of standardized field sobriety tests?
Yes, sir.
Through the NHTSA training? And have you reviewed the latest manual from NHTSA that explains the correct procedure for doing standardized field sobriety tests?
Yes, sir.
Is that part of your training through the Ohio State Highway Patrol?
Yes, sir.
What was the manual that you originally trained on?
2018 manual.
And this 2023 manual is the first one or the newest one that has been published, is that right?
Yes, sir.
And have you already gone through and reviewed those procedures?
Yes, sir.
As far as the actual conducting of the field sobriety tests, according to the standards set forth by NHTSA, has there been any substantial change in the way that the tests are conducted and the way that they're explained by the arresting officer?
No, sir.
Prior to the hearing today, did you look at some pages that I showed you, that I gave you to compare to the manual?
Yes, sir.
And did you see that those pages are copies that are accurate representations of what's in the manual?
Yes, sir.
I would stipulate to that.
So I'm going to show you a document that I'm marking as Exhibit 1, identification, and ask you if you can identify this.
This is from the 2023, this is SFST main, session 8, pages 23 through, give me 1 second, please. 37 discusses horizontal gaze and stagnant testing.
Are you already familiar with the procedures and the clues and everything involved in horizontal gaze and nystagmus testing?
Yes, sir.
And do you feel that the way that you conducted that test on this particular occasion is in substantial compliance with these standards?
Yes, sir.
It was the first test that you administered, the horizontal gaze and nystagmus test?
Yes, sir.
And I would like for you to, first of all, explain what horizontal gaze and nystagmus is.
So there's different types of nystagmus. Horizontal gaze nystagmus testing is for just that. We're looking for horizontal gaze nystagmus. There's 3 clues that we look for, and we look for those 3 clues in each eye. So we record 2 clues for, you know, if I observe that in one, like for example, the first was lack of smooth pursuit. If I observe that in both eyes, I record 2 clues. The next one, distinct and sustained, that's nystagmus and maximum deviation. If I see that in both eyes, that's 2 more clues, 6 and 4 total. Then if I would observe the last 2, one set of nystagmus prior to 45 degrees in each eye, so another 2 clues, which would be 6 out of 6 total if all of those are observed. If I observe 4 of 6 per the manual, that is an 88% likelihood that that person has a blood alcohol concentration of 0.080 or greater.
I would like for you to describe how you conduct the lack of smooth pursuit portion of the horizontal gaze nystagmus test, what you're looking for.
Sure. Do you want me to go over the pre-check as well?
Go over the pre-check first, yes.
Okay, so administrative procedures, raise your hand. The first thing I do is I'm checking for eyeglass. Next thing I'll do is I'll give the verbal instructions. The third part of the administrative procedure is providing, present stimulus 12 to 15 inches from the face. Once the stimulus is presented, I'm looking for equal pupil size and resting nystagmus. Mr. Sitter did not have any concerns there. His pupils are equal in size, and he did not exhibit resting nystagmus. The next thing I'm looking for is equal tracking of the eye. Both eyes tracking the stimulus is moving equally. Mr. Sitter did. From there, I checked for lack of smooth pursuit, and I observed that in both of Mr. Siffer's eyes. So two so far that I've checked for, and then checked for distinct and sustained nystagmus. The maximum deviation, again, I observed both of those clues in Mr. Siffer's eyes. So out of 4 checks, I observed 4 clues. And then finally, once that nystagmus prior to 45 degrees, I checked for those. I checked that in both eyes and did observe it in both eyes. So now 6 of 6. For the manual, that's an 88% likelihood that Mr. Siffer is impaired by alcohol at a blood alcohol concentration of 0.080 or greater.
I'll show you what I've had markings. This is Exhibit 2. And that's you recognize this document.
Yes, sir. This is the first page of the HP70B that I completed for Mr. Siffer. The HP70B is titled Impaired Drive Report.
And what does that show?
It shows that I recorded 6 clues of horizontal gaze nystagmus, as well as the other clues that I captured for walk, turn, long next stand, other observations as well.
So you stated previously, let's put this on your chest. You stated previously that according to studies conducted by the National Road Traffic Safety Administration, if an individual got 4 of 6 clues, that would be an 88% accuracy rate on the fact that a person had a BAC above 0.08. Is that correct?
Yes, sir.
And do you recognize this document I've had marked as State's Exhibit 3?
Yes, this is 2023's SFST manual session 8 and part of session 7. It covers the horizontal gaze nystagmus test criteria.
Does it say on there about the accuracy of that test?
It does. It says verbatim, using this criterion, the test is 88% accurate. Precede that by saying if a person exhibits at least 4 out of 6 possible clues, the indication of the DAC above 0.08.
And that's an accurate representation of what's in the manual.
Yes, sir.
I'm going to ask that exhibits 1 and 3 be admitted. 1 is the horizontal gaze nystagmus pages, and then 3 is the test criteria.
I've already stipulated to it, I don't care.
You do.
click on the bar right where the circle is, and it should start.
Right here.
Yeah, if you click on the circle, well, maybe not.
Bring up the,
I'm over here, it's still coming from my Bluetooth chiller. When I'm keying up, I'm getting that feedback even though I'm over here. I don't know why it's doing that. Yes, if I can change it. Yes, sir. Usually when I'm with Peter, I'll get feedback from him. Might be. All right. Chase, I'll ask you, sir, I came from the car. I'm going to ask you to do a couple things for me. Just so I can see that you're a safe operator in motor vehicle tonight. Like I said, these things I'm going to ask you to do are just for the purpose of, to see, I know you're not driving home right now, but again, I was just going to ask you to do a couple things so I can make sure you're safe. But I've asked you to stand right here for me. You wear contacts or glasses, anything like that? You wear contacts, glasses, anything like that? You have like a restriction?
Not really bad. I don't have any restrictions.
Okay, you don't have to wear like
I'm a lazy guy, like,
okay.
that's really bad.
You take any medications currently?
No.
Or do you have any history of head injuries because of present-day issues?
No.
And then would you consider yourself a native of all that? Yeah. Okay. Chase, only thing I'm asking you to understand, with your feet together for me, like all the way together, perfect, hands down your side. I'm just asking you to follow the very tip of my pen with your eyes wide open, okay?
Okay.
Please stay in bed with your phone. All right, Chief.
Trooper, in the defendant's motion, they allege that you held the stimulus in excess of the standard distance at times. First of all, what is the standard distance?
12 to 15 inches.
Did you maintain that distance throughout the test?
Yes, sir.
It's also alleged that you failed to move the stimulus in a manner that comports with the timing requirements as promulgated by Municipal. Did you, first of all, comply with the Municipal standards?
Yes, sir.
I would like for you to explain for the court how you are to move the stimulus during each part of this test.
Okay. So for the first one, lack of smooth pursuit, what I'm doing is I'm providing a stimulus, which is always, I always use the tip of my pen, and I'm moving it 2 seconds out from the nose. So I start with checking lack of smooth pursuit as I'm moving that stimulus. So if it's end to end, it's 4 seconds. It's 2 seconds from the nose. While they're tracking that stimulus, I'm looking for an involuntary jerking of the eyes, stagnance, in other words. Does that answer your question?
Is there, you say 2 seconds, explain that.
So the timing of it, so as I start at the nose, I'm going 1,001, 1,002. And then once I make it to that 1,002, I'm coming back across, 1001, 1002, 1003, 1004. Because 2 seconds from the nose, once I hit 1001, 1002, and I hit 2, I should be at their nose. And then moving 1, 2 seconds out from the nose again, I'll check both eyes, or both of the eyes twice.
Okay, so did you do that in compliance with the requirements of the NHTSA standards for lack of smooth pursuit?
Yes, sir.
On the next phase, explain what you are required to do.
The only time constraint on the next phase, which is distinct and sustained nystagmus maximum deviation, is that you're to hold the stimulus for a minimum of 4 seconds, but no more than 30 seconds. More than 30 seconds and eye fatigue becomes a concern. So holding the stimulus out, the maximum deviation that their eyes can track and still see. So as I'm holding it out, I'm holding it out there for a minimum of 4 seconds, and then once I check it out, I go to the other eye. Same thing, check each eye twice.
And did you do that correctly according to NHTSA standards?
Yes, sir.
With respect to the third, which I believe is onset prior to 45 degrees, how do you move the stimulus in that phase of the test?
So what we're doing there is using simple geometry and a right isosceles triangle, meaning if I'm holding that stimulus 12 inches from the face, or use 12 as an example, I only want to move it no more than 12 inches out to the side perpendicular. And that alone lets me know that I'm at 45 degrees. If I observe nystagmus prior to that 45 degrees, that's another report we need to make. We need to make that movement from nose to 45 degrees in 4 seconds.
Did you do that correctly in this case?
Yes, sir.
It's alleged that you failed to conduct vertical gaze nystagmus test, which is also part of the impaired driver report. Did you conduct that part of the test?
I did not conduct it.
And why did you not?
Vertical gaze nystagmus is designed to tell me whether or not it's a high dose for the individual of any of the 3 drug categories that apply for nystagmus, that being depressants, inhalants, or dissociative anesthetics. My goal, I do check for it now, but at this time, my mindset was I'm less concerned about if it's a high dose form. I'm more concerned about if they're impaired. Vertical gaze nystagmus doesn't in and of itself tell me whether or not they're impaired. It tells me whether it's a high dose for the individual. That's why I did not check for it this time.
So the fact that you didn't check for vertical gaze nystagmus, would it have an impact on your findings, your observations on horizontal gaze nystagmus?
No, sir.
Did you conduct a walk and turn test next?
I did.
That's not part of this motion. I'm going to have to check at this point. I didn't challenge any issues with the walk and turn, nor with the one leg stand test, as I believe that they would have been done in substantial compliance, and nor did I make a challenge as to probable cause to arrest for OVI. So I don't know that we even need to go into that, quite frankly.
Well, I think it's part of his decision to arrest him. I thought that's what this was all about, so we believe that it's appropriate.
Well, I'm taking it that there's going to be evidence of that if they're not objecting to it.
So it's not contested here that you improperly conducted the walk and turn test, but did you have him do the walk and turn test?
Yes, sir.
What were the results that you observed from the walk and turn test?
3 out of 8 clues per the manual. Observing 2 or more is 79% likelihood that that person has a blood alcohol concentration of 0.08 or greater. breathe out Jared where he moved his feet from balance from start, forward balance from the starting position. He started the test and he used his arms to balance during the test.
Are those all clues that you are trained to observe with respect to the walk and turn test?
Yes, sir.
Did you record those on the impaired driving report?
I might be able to save us some time, try to save us some time again. It's listed on the impaired driver report. If you just want to enter the impaired driver report, I won't have any objection.
Is it marked?
It is. I haven't had to admit it yet, but we're going to.
The next thing I'll ask you to do, let's come right over here. I will let you use that, that's pretty uneven, so we set you up for failure. So what I'll ask you to do is just stand right there on the light for me. You actually stand right on the light. Yep, right on it. And then I'll ask you to turn out face my car here. Only thing I'm asking you to do at this point, Chase, is to imagine a straight line from you to my front license.
Mr. Beal, why do we need this?
Okay, well, I'm asking you.
They're not disputing this. So I don't know why I need to see it.
Okay.
Yeah, I've got no dispute. We're good.
They're not challenging probable cause for arrest of ODI. I think you're.
He was already under arrest.
That it was not legally permitted for some reason because he was already under arrest, so.
And that there wasn't reasonable suspicion to do anything beyond the original arrest.
Okay.
For field sobriety in general, not to arrest again when he's already under arrest.
How about the modified lumbar test? Are you contesting that?
No, it really has nothing to do with anything. And quite frankly, I'm not even sure why it was done.
Okay. Well, we've got State's Exhibit 2. Your Honor, we asked for it.
Okay, there's no objection, it'll be admitted.
No objection.
So 1, 2, and 3 are admitted.
And if you want to go ahead and mark the videos, I've stipulated to those where, well, I can't remember whether that was 1 or whether the field sobriety was 1.
Yeah, this would be 4. Would be the video.
Okay.
So number 4, State's Exhibit 4, video, or
And I'm fine with all 3 videos just being marked as 4.
That's all I have.
are you finished? I didn't hear what you said.
That's all I have.
All right. Mr. Green, you can process them.
Thank you, Your Honor. Trooper Beam, you had indicated, I believe on direct, that you stopped Mr. Sifford for excessive speed.
Yes, sir.
And that was the basis of your reasonable suspicion to stop him.
Yes, sir.
You'd agree with me that speed, excessive speed, or speeding in general is not an indicator of impairment, and it's not listed as even a Q in the manual.
Correct.
Okay. Now, you also agree with me that there are the vehicle in motion clues that you would typically have for an automobile. There's a completely different grouping of those for motorcycles.
Correct.
Okay. So, and you wrote a full, accurate, and thorough report in this.
Yes, sir.
You didn't take any field notes, right? Did you take any field notes?
Is this a reference to Mr. McCown's last?
It wasn't going to be, but you've now brought it up.
Yes, I conducted this one the same as that one.
Okay, so they were just scribbles, they weren't on a NHTSA approved form?
Correct.
Okay, we can move on from that then. And you would agree with me that typically your memory would be better at or near the time of incident rather than what it would be sitting here at some later date?
Yes, sir.
Okay. So you've not alleged that there was any drifting by Mr. Sifford during a curve, right?
Correct.
He never had any trouble with the dismount off of his bike.
Correct.
Matter of fact, he dismounted sufficiently like you would expect a normal sober driver to do.
Correct.
He didn't have any trouble with balance at either time he was stopped.
Either time in the,
Well, he was stopped at the red light and you were behind him.
oh, I see, yes, correct.
Okay, so there was no problems with balance
Correct.
at that time. Also, there was no problems with balance once he had stopped,
Correct.
right? Didn't observe any turning problems.
Correct.
Didn't appear that he was inattentive to his surroundings, right?
Yes.
And you didn't observe any inappropriate behavior like public urination or anything like that?
Nothing of that sort.
Okay. And according to NHTSA, those are excellent clues of impairment.
They are listed.
Okay. And I believe the term that NHTSA uses is excellent, right?
I don't recall, but I'll take your word for it.
Okay. Well, if you're going to do that, it's fine. Additionally, you didn't list that you saw any weaving, right?
I did not list it, correct.
No erratic movements.
Correct.
He had his lights on.
Yes.
You didn't see him following anybody too closely.
No, sir.
Matter of fact, there really wasn't any traffic on the road at that time.
Just go, of course.
Okay, but nothing directly in front of him.
Correct.
He didn't run any red lights or stop signs, right?
He did not.
In fact, he stopped at the red light initially,
Yeah.
and then the two lights that you guys went through that you saw in the video were green.
Yes, sir.
And when there was a red light, he had stopped.
Yes, sir.
Okay. Wasn't traveling in the wrong direction?
No, sir.
Okay. So all of those vehicle in motion clues, or cues, I guess, you didn't witness any of those?
Correct.
Once Mr. Sifford had stopped and you got out of the vehicle, we saw the video, you were pretty upset. Is that fair to say?
Upset, no. Adrenaline dump, yes.
Okay. But would it be fair to say that you were a little excited over what you would normally otherwise do?
Sure.
Okay. And Mr. Stifford has his left hand on the clutch, right?
Yes.
And at that time, you didn't know that it was the clutch.
Right.
I think you said you're kind of, I guess, lack of a better way to say it, kind of ignorant as to the ways of bikes at that time.
I said that probably is the best way to say it.
Fair enough. I would indicate that I would have known that felt the same had he not explained that to me. And so you grab him and you put his arm towards his back, right?
Yeah, she noticed in the video, right, was getting out, the hands were off, and you put it back on the accelerator. That's why I grabbed it. That was my.
Sure, and I take no issue with that, but you pulled it behind his back at that point.
Yes.
So he couldn't use the kill switch with his right arm because you had hold of it.
Correct.
And then as he's trying to indicate to you that, hey, I can't let go of the clutch, during that whole period, you're also still kind of yelling at him a little bit.
Sure.
And so would it be fair to say that you're each somewhat trying to talk over each other?
Yes, I mean, that'd be fair.
Okay. So at that point, once, you know, the adrenaline kind of comes down a little bit, and Mr. Sifford gets a chance, he kind of says, look, if I let go of the clutch, we're going into the intersection.
Yes, yeah, he articulated.
Okay.
Fine, yeah.
Okay. And you were happy that he did not, I presume that he did not listen to you and let go of the clutch.
I'm glad he educated me that day.
Okay. So during that time, Mr. Sifford had the clearness of intellect and wherewithal to be able to say, hey, relax, I can't do this.
Yeah, he knew that he couldn't do it, or else I'm taking a ride with him, so.
Sure.
He was clearly conscious of that.
Sure. At that point, once you press the kill switch, he put his, as requested, he put his kickstand down.
Yes.
He relaxed the bike over on the kickstand. Is that fair to say?
Yes.
And then when you wanted him to, dismounted from the bike.
Yes, sir.
At that point, you moved him to the front of your patrol car and placed him under arrest.
Yes, sir.
Okay. At that time, did you read or give Mr. Sifford his Miranda advisals?
No, I did not.
Okay. What is typically the first thing that you were supposed to do
when you place someone under arrest?
Advise them that they're under arrest and Miranda.
Okay, and what are those mornings?
Yeah, I always say it the same way every time. They give us a card in the academy. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to the lawyer for advice before you ask any questions. Now have the lawyer present with you during your question. And they will pay for lawyer and will be appointed for you prior to any question. If you so desire, if you wish to answer a question now without a lawyer present, you have the right to stop answering questions at any time. You also have the right to stop answering questions at any time until you talk to the lawyer if you understand your rights.
Okay, and at that point, Mr. Sifford was not advised of any of those things?
That's correct.
All right. So he's then placed he's in the back of your patrol car, and he's cuffed.
Yes.
Audio goes off at that time due to admin. And I you know, I apologize. I actually missed that the first time that was the reason for the audio. I thought it was just a malfunction of the machine. But either way, there's some talk outside the vehicle with the other troopers, right?
Yes, sir.
That would be Trooper Martin and Trooper White,
Yes.
who arrived on scene as well. And at some point, I believe it was probably about 15 minutes later, you came back and opened the door to your cruiser. Is that correct?
Yes, sir.
You spoke with Mr. Sifford at that point and indicated that at that time, all you were charging him with was speed, and I believe you testified to that and said you respected that he stopped.
Yes.
Okay. So at that point, you weren't charging him, or excuse me, so at that point, he was just going to be charged with speed, right?
Yes.
You don't indicate anything about an OVI at that point, right?
To him?
To him, correct.
No, I did not.
All right. So you then, I believe, at some point, I don't recall, I believe it was before that, had asked him where he was coming from. He said Ironton.
I don't recall that.
Okay.
He was coming from that direction, I'm sure he was.
Okay, we can play the video maybe here in a second, portion of it. And you had asked him if he'd had anything to drink.
Yes.
And his response at that point was one beer, right?
Yes.
But you hadn't Mirandized him.
Correct.
And with him being under arrest, would you agree with me that that changes the scope of your inquiry?
So my line of thinking at that point was he's not, yes, he's clearly, you know, in the back of my car at this point, but I've already told him he's not going to be charged with any of that. So that was the line of thinking.
Okay. So, and we're going to play the video because I believe your questioning came prior to you telling him that. But you then later say, but just because I'm only charging you with speed, I'm still towing your bike.
Are you asking me if I said that?
Yes.
Yes, I said that.
Okay. Does the State Patrol have a policy of towing bikes for speed only?
Well, okay, so I see what you're getting at. The point is, you know, as I've already articulated, it's reckless operation. It was speed that he was being excited for at that point, based on the indicia that I had at that point alone. However, at the same time, you know, just because I can't just charge him for, you know, I had already made the decision, basically. I'm not charging him with failure to comply.
Okay. You also didn't cite him with reckless operation?
I did not.
Okay. It wasn't until that point that you made, anywhere on the video, you made any mention of any type of, anything to do with alcohol, right?
Correct, yes.
Okay, so about somewhere between 15 and 17 minutes into the stop. That's the first time you've indicated anything when you had asked him if he'd had anything to drink.
Yes, sir.
Okay. You didn't at any point, you know, indicate, and I didn't see anything on there to show me this, but at no point did you indicate anywhere in the video that you had smelled the odor of an alcoholic beverage coming from him up to that point.
I not articulated it, no.
Okay.
Not allowed.
Okay. You had indicated as well that there was bloodshot and I believe you said watery eyes, right?
Yes, sir.
You agree with me, watery eyes is not in the manual as an indicator of impairment? Okay. There was no soiled clothing?
Correct.
Didn't have any indication of fumbling fingers?
Correct.
You didn't find any alcohol containers on him or his bike.
Correct.
You didn't find any drugs or drug paraphernalia.
Correct.
No bruises, bumps, or scratches.
Correct.
I guess it wouldn't really be applicable because he didn't have an opportunity to provide his documents at that point. But I believe on the video, with his wallet, you had taken out his ID and had looked at his ID to identify Mr. Sifford.
Yes, sir.
Okay. You recall in the video where I believe it was Trooper Martin comes over and asks him for his ID, and he says it should be in my wallet on the hood.
No, I don't recall.
Okay.
Sure happened that way.
Okay. And okay. So as far as the sight indicators that you witnessed, there was bloodshot eyes.
Water and bloodshot eyes, yes, sir.
Okay. But again, you've agreed with me that water is not an indicator. It's just bloodshot
I
eyes.
agree it's not me.
Okay. You didn't observe any slurred speech.
Correct.
So his speech was normal.
Yes.
And I believe that's on the impaired driver report throughout the entirety of the time.
Yes, sir.
He didn't really give you any inconsistent responses, did he?
Answers changed along the way, not like a malicious way, but they did change. You know, for example, I wasn't running, and then if you're talking about prior to the arrest, I think the answers were relatively the same.
Okay. I'm talking prior to you moving Mr. Sifford to conduct standard field sobriety testing.
Okay, yes, answers were consistent. Yes.
Okay. Didn't really make any unusual statements?
No.
And didn't really give you any abusive language?
No.
Okay. So the 5 hearing clues, there were none?
Yes, correct.
Okay. You've indicated at some point you smelled the moderate odor of an alcoholic beverage. Was that fair to say?
Yes, sir.
It's not on video as to exactly when, right?
Sure.
So we don't know whether it happened before you asked him of drinking or after.
Correct.
Didn't smell any cover-up odors.
So can I backtrack a little bit there?
Mr. Hill will have an opportunity to
Okay.
question about that. You didn't smell any cover-up odors.
No cover-up odors.
No marijuana.
No.
No other unusual odors.
No.
Now, there were several times, excuse me. So during phase 2, personal contact as well, you were taught to ask questions and different things to divide the attention.
Yes, sir.
Was there any questions that you asked and gave him for divided attention that he didn't complete appropriately?
After he was arrested for driving a bike.
All the way up until you moved him to conduct field sobriety testing? Okay. During phase 2, you're taught to ask about medical conditions that could mimic impairment.
Sure.
And you didn't ask him about any of those during phase 2, did you?
I asked him as part of the pre-arrest screening.
Okay. Well, those medical conditions that they teach you to ask for, do you recall them teaching you to ask if he's got any disabilities?
So there's various ones, that's one, yes.
Okay. Did you ask him if he had any disabilities? Did you ask him if he was sick or injured?
Pre-arrest screening, I asked him if he was good physical health overall.
Sure, but did you ask if he was sick or injured?
I mean, that would qualify under good physical health.
It could, but it doesn't necessarily have to. But the question is, did you ask him?
Specifically, that question is part of it.
Did you ask him specifically if he was sick or injured?
I did not.
Okay. Did you ask him if he was under the care of a doctor or dentist?
No.
Did you ask him if he's diabetic?
No.
Did you ask him if he's epileptic?
No.
Did you ask him if he's taking any medications?
Yes.
Okay. And that was during the pre-arrest screening, right?
Yes, sir.
So those medical questions do several things. And correct me if I'm wrong, but the first thing they do is they allow you to determine whether what you're seeing may mimic impairment.
Yes.
Secondly, they also divide the driver's attention, because they have to recall what these things are and answer your question appropriately.
Sure.
Right? So those are things that you could have done during phase two to attempt, and I understand that, you know, we've already kind of talked about the Miranda issue and that he was already under arrest and everything comes later, but during that phase, you could have done those to attempt to develop further reasonable suspicion.
I would contend that I did, but I guess agree to disagree.
Fair enough. There's also divided attention tasks that you could have done, right?
Yes.
And that would be the alphabet technique,
Yes.
the finger technique,
Correct.
and the countdown technique.
Correct.
You didn't do any of those, did you?
I did not.
Okay. So at that time, or at least at some time around that time, the only thing, the reasonable articulable suspicion that you've indicated would have been an admission to drinking, a moderate odor of an alcoholic beverage, and bloodshot eyes.
Water bloodshot eyes, I articulated some too about leading up to stops, some points of interest, such as the decision-making, the decision-making in going stop, but I'm not going stop, but I'm going stop, and different avenues, such as that, as I talked about already.
So now you know what Mr. Sifford was thinking.
What do you?
Well, you said Mr. Sifford's judgment, what he was thinking, he stopped because of these reasons, is what you testified to earlier. So you know what Mr. Sifford was thinking at that time.
If you ask me, I know specifically what's going through his head. In other words, we all know thoughts become actions. He didn't want to stop. He looked at me. My lights were on. My siren was on. He has the opportunity to, if he really wanted to, go to West Virginia and never see me again.
But he didn't do that.
Correct. That's
He did
odd,
stop.
isn't it?
Why would it be odd for him to stop when you're trying to get him to stop?
Why did it take a while to do it? Why did he want to run and then not run? Or why didn't, better said, because I don't think he's actually trying to run.
That's what I was going to ask you next.
Why did he decide to not stop and then stop? That's peculiar behavior. That is not normal, sober thinking.
Sure, and it doesn't list that as an indicator, does
Sure,
it?
absolutely. I don't contest that.
Okay. Let's talk a little about the field sobriety testing. So you've testified that,
We weren't going to get into that.
or this is the horizontal gauge of the stack, Mr. Honor. That's the only one that,
All right.
and I was going to say specifically the horizontal gauge of the stack test. You testified that you did that test in substantial compliance to the NHTSA rules.
Yes, sir.
Okay, let's talk about some of those rules. The verbal instructions. Did you tell him to put his feet together, hands at his side, and keep his head still?
That's, yes.
Okay, so you told him all of those things.
Keep your feet together, hands on your side, just follow to my hand with your eyes and eyes open.
Okay. Did you tell him to look at the stimulus?
Follow to my hand with your eyes and eyes open.
Okay. But did you tell him to look at the stimulus?
Word for word?
No.
Is that what you're asking me?
That's what I'm asking. Specifically, did you utter the word to look at the stimulus?
No.
Did you tell him not to move his head?
No.
Okay.
Yes, actually, I did. I apologize. I did tell him to not move your head.
Okay. Did you tell him to keep looking at the stimulus until the test is over?
No.
Did you ask for his understanding?
No.
Okay. So you've testified, or at least, I think you testified to this as well, as far as equal tracking goes. The timing that you're required to move the stimulus is 2 seconds out and either 2 seconds back to the tip of the nose or 4 seconds all the way out.
Yes.
Okay. Go back.
Chase, only thing I'm asking you to understand, was your feet together for me, like all the way together, and he's on your side. I'm just asking you if that.
Okay, so at that point, did you tell him to keep his head still?
Not at that, no.
Okay, so when you testified earlier that you testified, you indicated to him to put your feet together, hands on your side, and keep your head still. At that point, you would agree with me that you have been informed him to keep his head still.
So my specific testimony was I told him to put his hands together, keep his feet together, hands on his side, follow to my penalty, eyes and eyes on. It did say that I told him to keep his head still. That was later after I corrected him.
Okay.
Not up front, if that's your question.
That's
Not
my
up
question.
front.
Okay, so.
On the very tip of my pen, with your eyes and eyes on, okay?
Okay, and at that point again, did you tell him, don't move your head?
Yeah.
Okay. Just make sure you're awake. All right, so now, let's go back just a touch here. We're going to start with the initial pre-check. Now, the pre-check, you've indicated you're supposed to, the timing requirements, 2 out, 2 back to the center, or 4 across, right?
Yes.
You want to take a look at the time here when you start, and we're going to see if you went 2 seconds out from.
I'm just asking you to follow the very tip of my pen, with your eyes and eyes on, okay?
Okay. So at that point, did you go 2 seconds out?
Yes.
Okay. Now, from that point, so if you'll look, now, I believe this test, you started this test at moving the stimulus at 7. So at 7:17, I think you're going to start at 7:18. Okay?
Okay.
Okay, it's now 7:20 on that. And you've already crossed back over and you're over here. Would you agree with me that that wasn't 2 seconds going out? That was faster.
I mean, if we're just going off the video, it's hard to tell. It's a matter of perspective here. I mean, and I've told you how I count. I mean, I'll be the first to tell you I don't have a stopwatch on, so you have a reason to do that.
But if you look at the video from when you started to now, 2 seconds have elapsed.
Yeah, yes.
Okay.
I'm just asking you to follow the very tip of my pen, with your eyes and eyes on, okay?
Okay. Now you're all the way out again, right? Since you started, 3 seconds have elapsed. Is that fair to say?
Yes.
Video. Okay. So at this point in time, 6 seconds should have elapsed per the rules. So at this point, you're moving the stimulus at double the speed.
Based on that math, yes.
Okay. Well, not the math, the time.
But, you know.
Seeing it on video, right?
Yes.
Okay. Now from here, we're going back across. Okay. And at that point, 3 seconds have elapsed. Is that fair to say?
6 seconds.
Or from
Oh, you mean from, yes.
From where you were across?
Yes, sir.
Okay. So it's supposed to be 4, right?
Yes, sir.
It took 3.
Yes, sir.
Sorry. Let's get back to this portion. Okay. So let's see how far it goes going across. All right, so another 3 seconds. Is that fair to say?
Yes.
All right. And this would be your second pass.
Yes.
That's correct.
Should be concluding the group check.
Okay. Okay, now was that your perceptible delay right there between
in with your eyes wide open, okay?
Okay.
Okay, so we're going to start back up again, and the timing requirements for lack of smooth pursuit are the same as the pre-check.
Yes, sir.
Okay. 17:27 on the clock, correct?
Yes, sir.
Please stand together.
And we're going to start over because you corrected him.
Good job.
So 7:32. Okay, so 7:32, and you've completed the passes at that point at 17:41.
Yes.
Is that fair to say?
Yes.
So 9 seconds have elapsed.
Yes.
All right, so with the timing requirements being the same, you've got 2 seconds out, right? 4 seconds across.
Yep.
That's 6 seconds, right?
Yes, sir.
2 more back to the center of the nose.
Yep.
So you're at 8 seconds. And then you've got to do a whole other pass
Right.
at that time. So at that point, you're talking 16 seconds to complete a proper 2-pass through. Is that fair to say? Time requirements.
Maybe math. Is it not 12 seconds? It should be in total.
Well, if you've got 2 seconds out, correct?
Yes.
4 seconds across,
Yep.
right? So we're at 6.
Right.
2 seconds back in the center. We're at 8, correct? And the math for
No, you're right.
the
I
same.
forgot the last part.
Okay, so you agree with me, it was
Yes.
16 seconds to do it properly.
Yes.
All right, and you did your passes in 9 seconds.
Yes.
And that, you agree with me that that is a significant deviation from your training?
It is different than math. Yes.
Okay. And you were trained on that manual,
Yes, sir.
right?
Yes, sir.
Now, we're going to move past these clues. Excuse me, this portion of the test. Okay. So now we're going to move on to onset prior to nystagmus prior to 45 degrees. Now, it was in the exhibit that was entered, but what is the timing requirement that you're supposed to do the stimulus toward 245 degrees?
4 seconds.
Okay. So it's 4 seconds, which is much slower than you were otherwise required to do at 2 seconds, right?
Are you saying that's
Or
all?
excuse me, on the prior ones,
Which test you talking about? Are you talking about?
strike that. So you're supposed to move it from 4 seconds out till you get to 45,
Yes.
right? And if you've seen a nystagmus at any point during that time, you're supposed to stop and make sure that it is actual sustained nystagmus, that it's there.
Yes.
Okay. Do you believe that you moved the stimulus at 4 seconds?
I'm sure there's some deviation.
Okay. So we're at 18:17. It may flip to 18:18 before you start, we'll see. Okay. So at that point, good 4 seconds. Do you agree with me?
Yes.
18:17 to 18:21. All right, go back. And it's 18:25, right?
Yes, sir.
18:28. So 3 seconds. So you're a little fast on that one. Is that fair to say?
where we're stopping it when we would see it, so it might not take a full 4 seconds.
Fair enough. Okay, so we're 1831. 3 seconds.
No, I shouldn't get.
And we're 1837. It was 1840. I originally stopped it. Is that fair to say?
Yes, sir.
So 3 seconds.
Yes, sir.
Okay. You'd agree with me that the NHTSA manual specifically indicates that in reference to the study that you cited, San Diego study, the manual specifically says it is necessary to emphasize this validation applies only when the tests are administered in a prescribed and standardized manner. The standardized clues are used to assess the subject's performance, and the standardized criteria are employed to interpret that performance. If any one of the SFST elements is changed, the validity may be compromised.
Yes.
Okay. Now, we've already discussed that you were significantly fast on the lack of smooth pursuit, right?
Significantly is your word, but deviation, yes.
You were nearly double the speed.
Agreed.
Okay. One moment, Your Honor, I may be finished or I may only just have a couple more questions.
Okay.
Now, you had indicated that the HDN test, if done correctly, as the manual states, is considered to be 88% accurate, according to the California study, San Diego study.
Yes, sir.
All right. So 88%. So if I were to hand you a bowl of M&Ms and there were 12 of them were poison, would you eat them?
I don't object, Your Honor. I don't know what the relevance of that is.
It's the statistical, the efficacy of the
Just
test.
saying, I don't think that helps me any.
Guess that is more of a question for a jury. Would you agree with me as well, going back to the HDN battery, you indicated that you didn't do vertical gaze nystagmus.
Yes, sir. That's correct.
And when Mr. Hill was questioning you, he asked you why you didn't do it, and you explained it.
Yes, sir.
You would agree with me that that is part, according to NHTSA, of the horizontal gaze nystagmus battery.
That is the 10th and last component of the administrative procedures of HDN.
Okay. And again, you didn't perform that portion of it.
That's correct. I did not.
I don't have anything further, Your Honor.
Mr. Hume.
Thank you, Your Honor. Trooper, you gave some testimony, and it was pointed out that maybe there were some things that weren't strictly by NHTSA standards. Did he look at the stimulus?
Yes, he was focused on it the entire time.
Did he keep looking at the stimulus?
Yes, sir.
Did he perform it correctly, even though you might not have asked him if he understood the directions?
Yes, and you'll, maybe not in this case, but there's other cases. I'm sure you yourself have seen if they're not doing something I want them to do, I'll correct them and start over.
So were you able to get an accurate reading based on him not moving his head, following the stimulus, and not stopping until it was complete?
Yes, sir.
With the deviation in the time that was asked of you by Mr. Cremines and the answers that you gave, was the difference in the time vis-a-vis the NHTSA standards so significant that it kept you from being able to record accurate observations on the HGN?
No, so, I've kind of articulated somewhat how I'm counting in my head. It's 1001, 1002, 1001, 1002, 1003, 1004, and so on until the test is completed. That's the way I counted in the academy, and it's the way I've been taught to count, so, in my mind, that was the observation at the time. They were in line with what I was seeking to look for in terms of the test.
That's all I have, Your Honor.
No follow-up, Your Honor. I'm not Mr. McCown, so I'm not going to
Thank you.
pound that in there.
You did want to say something previously. I don't know if you got to answer that question or.
I apologize, Your Honor. I forget the exact question. No, it has something to do with when I observe something during a stop. I don't recall.
All right, just want to give you the opportunity if you wanted to say.
Thanks, sir.
You may step down.
Thanks, sir.
We rest, Your Honor.
Anything from the defendant?
No, Your Honor. Not by way of testimony.
Okay, well, here's the thing. I want to do this the way I did the last one. When was here. There's some things I'd like to be educated on. We didn't talk about this the last time, but this whole excessive speed thing, that it's not included, that makes no sense to me. That just seems very illogical. Because, I'm a human being, I live in this world, and I see when people consume alcohol, their judgment is impaired. And one of the things about judgment is, well, what can I do safely and what can I not do safely? And I think when people that drink alcohol are very well known for engaging in activities that are not safe, like driving at excessive speed. So this whole thing that excessive speed cannot be included, you're going to have to convince me of that, because I'm not convinced. I want to see some authority on that. Are there courts in Ohio that says, oh, absolutely, a guy's going 100 miles an hour, and you can't consider that as part of a clue that he's impaired? I don't get that. So, Mr. Cummings, give me some authority on that. I want to see it.
I can do that, Your Honor, and even in my closing here in a second, I can give you the brief.
No, I want to see it in writing. I don't want to hear closing. I'm done. I don't want to hear closing. Failure to stop in a reasonable time frame, same thing. I mean, to me, that is a clue of possible impairment. And back to the excessive speed, does that mean that everybody that drives 100 miles an hour is under the influence? No, but I think it can be an indication that someone is not making good judgments, and the reasons they're not making good judgments because they're under the influence. Okay, we've got odor of alcohol testified to, bloodshot eyes. The admission of one beer has got to go out because Miranda warnings weren't given. So, I want to know, is that enough indications to go on? Because it sounds like, from what I'm taking, is the field sobriety tests are going to show that there was probable cause to go forward. We never got to those past the HGN. So, is substantial compliance, is this whole time issue, is it substantial compliance with the HGN? So, those are the things that I'm looking at. I guess a further issue is, it's almost implied, is the only issue about the arrest the Miranda warnings, or is there, it's almost like I thought you were arguing at one point, Mr. Green's, oh, once you've arrested for one thing, then you can't investigate him for something else, which I found that hard to believe too.
It's partially that, Your Honor. He was under arrest at that point, and I don't believe from the testimony and what would be shown in the video, I think that the initial purpose of the stop was speed and failure to comply. Don't contest that he could have been arrested for failure to comply and that there would have been probable cause for that. The question is from that point going forward, specifically without Miranda advisals, was there enough reasonable suspicion to continue on to conduct an OVI investigation in lieu of the Rodriguez case that would be for the purpose of the stop?
Well, let me tell you my thinking, and you can educate me and disabuse me. What I'm looking at, the only thing that goes out is the admission. because it's custodial, you know. Once somebody's in custody, they have a right to know that they don't have to make admissions against their interests. And he made a custodial admission that he drank beer. So that can't come in. That's fruits of the poisonous tree, because you didn't get Miranda. But the other things that are just observations, I don't know that they come out, that you can educate me on that. I'm going to flip the script on this one a little bit, because I think the defendant needs to go forward and address these issues first and let the state respond to it.
However you want to do it, Your Honor, it's fine by me.
Give me a writing with the authority, and I want you to address this excessive speed. I hope you're making good notes of.
I am, Your Honor.
Are the clues that's been testified to enough without the admission of the one beer? Because I'm going to rule that can't come in. Was the HGN substantial compliance? Can it be used? And then, I guess the other thing is, do we have to stop? I mean, I think your argument has to be, Mr. Creans, that, well, if HGN is not done correctly, you can't go on to any other field sobriety test. Because you're kind of admitting that those wouldn't have helped your cause.
I don't know that they were detrimental, Your Honor. I just didn't have any, I felt that the trooper performed those appropriately, gave the appropriate instructions and substantial compliance, and I didn't have anything.
Since they didn't come in, I'm going to say there must have been clues there, otherwise they would have come in. So those are the things I'm concerned about. When can you submit something?
Can I have 2 weeks, Your Honor? Next week I'm going to be gone to A-RIDE training.
And so you're going to submit by the 20th, and then how long do you want to respond? Because you got another one coming due with Mr. McCown.
He just filed that today, Your Honor.
Oh, you already filed it. Okay, well, you got all.
I've got nothing. It's almost like living on a vacation for me.
That's right. This weekend, you need something to do, and you're not even going to have.
I think we've got another one of these on Tuesday.
This time it's not us.
One other thing too, and I don't know whether this really plays into what you've given Mr. Cremeens to do, but we also believe that the way that he initially responded to the direction to turn off the motorcycle without being able to verbalize a response, I think
kind of slurred, incoherent speech, I would say.
Yeah.
Yeah, that's true. Okay. So I'll give you 2 weeks then, so also to respond. So that's November 3rd.
So when's Brian's?
This is due in 2 weeks, the 20th.
And Your Honor, I'm not asking for any additional time to respond to Mr. Hill at this point, because I may not need it. But in the event, I would like to reserve the ability, if we show up, then if I need to respond, to be able to request it.
Well, what I'm going to do, I'm going to put it down for the 10th, so that gives another week to respond
That'd
if
be
you want to. If you want to mark it for argument that day, if you want to come back and if you make your closing now, and then I'm going to read these briefs over the next month, I'm not going to remember your arguments. If you want to make your argument.
And that's fair, because after going further in depth on this, that may change my closing anyway.
So you want to set it for
that'd be fine.
Potential argument on the 10th and your filing? Okay, so I'm just going to put it down as a decision that day, but if you want an argument.
Do you want me to put it down as another day?
Well, let's put it at noon.
Okay.
So if you want to come and argue it, you can, you don't have to. You may think, after you write your materials, like this, what I've written is so amazing, I don't need to argue this.
I felt like that the other day, and it was the first time in 4 years, so I'm probably not due for another one of those for a while.
Okay.
I would like to mention, though, Your Honor, part of my motion did deal with the test, and there was no evidence of that put on today.
All of the BAC?
It was specifically Let's see here. Number 6 in my motion on page 2, Your Honor.
Well, we didn't address it, so.
And then 9 as well.
And that's one, I like a quote, one of the Court of Appeals, I need to get that decision out. When you object to everything, you object to nothing.
I get that, Your Honor, but in this case.
But there's just so much. I mean, basically you guys are coming in and saying, okay, prove your case now in a motion.
Well, I didn't receive.
But what this is, that's not what these motions to suppress are supposed to be about. Motions to suppress is supposed to be about, Judge, there's a real problem with this evidence. Here's the real problem with this evidence, and we want to bring it up early and not bring it up in front of the jury for the first time.
I can brief that issue for you as well, Your Honor, if you'd like.
Well, I'm gonna reserve on that. I'm not gonna say you win on that. We'll see how this goes, and then we may have another hearing on the BAC, because there wasn't even any discussion about the BAC.
We discussed it prior to, Your Honor. I didn't receive any of the information in discovery, which is why it wasn't a specific issue as far as that goes.
There wasn't, I mean, it was probably brought up in discovery, but what it requires is a subpoena to the Ohio Department of Health. And our feeling on it is twofold. One is that it is public information that's available online at a website, which we've provided in discovery today. You can go there and get it all yourself. You can't get the certified copies, but it's all public. It's out there for people to get. So us having to provide it, if we have a hearing on it, we would have the certified copies as we would need to, but.
Well, do you want to stand on that and then let him argue it, or do you want to reserve it so that you can provide the certified copies later?
Well, we're subpoenaing the certified copies, so we'll get those. But I also, I mean, I think that there's a step in there that if something's not provided and you intend to use it, that you compel that. You file a motion to compel the discovery.
Well, the problem I have with most of these motions is they're a shotgun. There's just like everything that possibly in the world that could be an issue is shot at you. So how do you know what to actually prepare for? So maybe we need to do more and put it on the record before, at the pretrial on these motions, that what are the specific issues that are going to be addressed, rather than say, okay, you got to prove everything specifically, or we're going to object. Okay, so this case is submitted the way that I just laid out, and I'll take a look at it, and then we'll go from there after November 10th. Court's adjourned.
Thank you, Your Honor.
You're welcome.
All right, pop outside. I'll be out in a second.
I think Tuesday is you, isn't it? Over?